10 seconds.
All right, I'd like to call the meeting to order. If you can please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic under God, indivisible, with liberty and justice. Next, we have roll call of board members. Aaron's,
Here.
Olnick,
Here.
Slupsima here, and Kester here. Wendy Hoaxma is excused to be late for the meeting. She's attending an elections required meeting right now, but will join us as soon as possible. Moving on to set, adjust, and approve the meeting agenda. Does anybody have any adjustments to the meeting agenda? No.
No. No, and we can't anyway,
Okay,
right?
no adjustments, correct. So I'll make a motion to approve the meeting agenda as written. I'll second. Seconded by Kester. All those in favor? Aye. Those opposed? None opposed. That passes. Okay, declaration of conflict of interest. Does anybody have a conflict of interest with the content of today's meeting?
No. No.
No? Jill? No. All right, no conflict of interest noted. So next we have a presentation by our township attorney, Mr. Peter Wendling. He will be at the podium, and copies of his presentation are on the small tables by the doors. He will go through this presentation to start with. One last thing, if you plan on making a public comment, there are papers there to please fill out your name and address so that we don't have to spend a lot of time asking you to spell your name if you have a public comment today. And there are materials there, both the agenda and the presentation you'll be seeing are there. So we're going to get started with that now. Thank you for being here, Peter.
Oh, you're welcome. Well, good evening. I think this is the first time I've been before the entire.
Yeah, Joe, that's a little soft here.
It's a new one.
Hang on, he's.
Does that sounds, yeah, looks like we're good. Okay.
Good.
Again, this is my first time before the township board. So I've met some of you actually for the first time this evening. I'm from Balkenthal, Sieber, Kaufman, and Koches. I joined the firm at the beginning of June, but just to give some background information, I've been an attorney for 33 years. I started work at a personal injury firm down in Detroit, went to a small firm that handled matters for the Detroit Federal Teachers Credit Union for all the teachers in Detroit. Became, because I wanted to move up north, an assistant Antrim County prosecutor back in 1995, and then joined the firm of then Young, Graham, and Elsenheimer in 1999, whose focus has been municipal law, and became Young, Graham, and Wendling. And my senior partner, the last of the two of us, Brian Graham, retired in the beginning of 2025. And so we actually transferred over 65 municipal clients that we had to Balkenthal. I worked in probate for a little bit, but was more interested in the municipal side. And so they allowed me to come back. And so here I am. So I've had 27 years of working for municipalities, road commissions, fire districts, and so forth. So tonight we're going to talk about municipal civil infractions. Let me start the program here. Well, I always like the disclaimer on here. That's just for the general public. And of course, for the township, you know, the advice is still there for between us as attorney and the township. All right, we have this all lined up in 4 parts here. The first, we're going to talk about the framework of Michigan law and enforcing the township ordinances, what you can do. The difference between civil infraction enforcement or the very old style misdemeanor, which is generally not used anymore. And then kind of putting it all together and discussing enforcement of the ordinances in Whitewater Township, and then some recap and potentially some questions and comments from the board members at the end of the presentation or as directed by the board. All right. Most townships have usually some form of ordinances. Usually there are a couple out here. Central Lake Township, I'm not sure if they have any ordinances on Torch Lake. So it depends on the township and what you decide, what the electors decide they wish their township to look like, whether you have a zoning ordinance or whether you have one or more different types of police power ordinances. Police power ordinances do not regulate land use. That is strictly for zoning. Zoning ordinances regulate land development, zoning districts, setbacks, dimensional regulations, height, density, and things of that nature. Most police power ordinances address other items that are behavioral oriented, anything from your grass is too tall, cutting the grass, junk, nuisance ordinance, dismantled, inoperable motor vehicle type of ordinances, dangerous structures ordinances, and so forth. So that is the difference. And also the difference is that under a zoning ordinance, if you had a land use that pre-existed the regulation under the zoning ordinance, that land use can continue as long until it's voluntarily relinquished as a lawful non-conforming use. The same applies to zoning ordinance amendments that come into play afterward, which may regulate a use, but the unregulated portion of that use is also grandfathered in, again, until voluntarily relinquished by the landowner or their successors in title. Under police power ordinances, there is no grandfathering in. So if you pass a nuisance ordinance of any type, whatever activity was not regulated before becomes regulated, and you have to abide by the ordinance to the extent, of course, that it's lawful. So under Michigan law, you generally have two types of penalties possible under these ordinances: criminal and civil infraction type of violations. Practicing for over 27 years in municipal law, I've not come across a township until a Whitewater Township that still maintains or has a criminal violation for its ordinance for enforcing its zoning or its police power ordinances. And the reason being is that we're not regulating, types of behavior such as theft or disorderly conduct or things of that nature, which are generally criminal in nature. And the courts have generally frowned upon the use of criminal penalties for municipal ordinances. I've had some comments in the past from at the beginning when I started practicing, where I talked about this with judges throughout northern Michigan. Not just the 86th District Court, but courts throughout northern Michigan where I practice. And again, I have not seen, since the beginning of the time in around 1999, there may have been a couple, but I do not see criminal penalties in any ordinances. So through a civil procedure, obviously there's a difference. If you have criminal penalty and criminal violation, you have a right to a judge or a jury trial at the option of either the municipality or at the option of the defendant. You also have the expense of having to address the prosecution. You have to have a warrant. You have pretrial meetings. You may have a status conference, pretrial meeting for pleas and so forth. It's expensive. It's also time consuming. You have a right to a jury trial, and more of this will come up later in the slides. And the violation is has to be proven beyond a reasonable doubt. Under civil infractions, you still have the appellate rights that you would in a criminal case, but it's generally enforced through the district court through an informal and formal hearing process, which I'll talk about as we go through the slides. But you are allowed to appeal your hearing, whether it's an informal hearing, to the district court judge and so forth up through the circuit court. Now, you may have civil infraction. We're going to talk about bureaus and notices. In most cases, municipalities no longer use civil infraction notices. And we had talked about that. That's why we ended up putting the not applicable. But most zoning administrators will work through the process, talk to the property owner or the individual who's renting and discuss the ordinance violation, try and gain compliance through that method. And if that doesn't work, we step into the next procedure, which is a written notice, or usually it's in the form of a letter in the case from the zoning administrator outlining previous conversations. And so you start to build, your record, but you're also attempting to ensure compliance so that as a last straw only, do you want to go to court, whether it's a criminal violation or a municipal civil infraction. There are two types of hearing for civil infraction. Generally, under the revised Judicature Act, if you have an informal hearing, it's going to be through the magistrate. Now, the act does allow the district court judges to assign a magistrate the authority to engage in what's called injunctive relief. I have not seen that occur in any jurisdiction in northern Michigan. So through an informal hearing, attorneys are not allowed. The rules of evidence are generally not followed. The zoning administrator or code enforcement officer would be the one making the presentation on the violation. And of course, any witnesses can be called by either side, but ultimately the magistrate then decides whether or not the violation occurred and whether the defendant is responsible. Note the term is not guilty. Again, it's not a criminal procedure. Whether they're responsible for violating the ordinance, in which case the magistrate's only authority generally is to issue a fine. They do not have the authority to provide the injunctive relief, which is otherwise assigned to the district court under the revised Judicature Act. Now, even if it starts off as an informal hearing, either party before that hearing occurs can make a decision, even up to the date of the hearing, in which case they reschedule things, requesting that a formal hearing be done instead of an informal hearing. That will generally put you on the district court judge's schedule. All right, we're going to talk about the differences. I did partly, on the informal hearing. But let's talk about, we went through some of this already. See, the warning letters is the same. The warning letter is the same thing as the notice as before. There's going to be discussion about which ordinance has been violated. It's a good idea also to provide additional evidence besides testimony. There may be photographs that are taken and kept by the zoning administrator or the code enforcement officer. Those will be presented in order by the zoning administrator or code enforcement officer to the magistrate. There may be witnesses who would testify regarding the violation. And then you would have an order. Generally in the informal hearing process here, the court will issue its own order. You can prepare one, and have one prepared by the township attorney. I have done many orders under what's called the 7-day rule, which I'll discuss when we talk about a formal hearing. And of course, the township representative, who's the code enforcement officer, should understand what the procedure is in court, and of course, be respectful toward the magistrate as well as the witnesses and so forth. And my experience with most zoning administrators is that they generally are trained, by the township, and then I of course work with them even if it's an informal hearing, and certainly more so for a formal hearing. In the formal hearing, the attorney is required to represent the township or any municipality, village, city, county. And the purpose behind the formal hearing and the better part of it for understanding the importance of enforcing your ordinance is the injunctive relief. It's not about getting the fines and costs. Those are very much secondary. The goal behind it, the formal hearing, is to utilize the court procedure to obtain relief through an order which requires the defendant then, who is found responsible of violating the ordinance, to comply with the zoning ordinance or clean up the property. If it's something more extensive, and most ordinances, including the zoning ordinance, has it, where the costs exceed the jurisdictional limit of the district court or some discovery is needed, what's not on these slides, you still have the option to file an injunctive complaint in the circuit court and start the process there. But those are for more complex matters, where you need discovery, and you may be asking under the zoning ordinance where someone built a structure that they weren't not allowed to build, and asking the court to rip down that structure. You're not going to get that type of relief generally from the district court judges, in my experience. They have some authority to do that, but if someone says, hey, this cost of doing this exceeds the jurisdictional limit of the district court, which is $25,000, that's not the place to go for items, big ticket items such as that. Michigan court rules and the rules of evidence are adhered to during the formal hearing process. You still have the ability to obviously to present evidence that's marked in the form of photographs, testimony, affidavits would come into play as well. And the zoning administrator and the code enforcement officer would also be involved with any additional witnesses in the cases presented. And then the district court makes its ruling. With a formal hearing, if the violator doesn't appear, normally the court will allow the municipality to request an entry of default and a default judgment and the relief requested. And I'll go over that relief a little bit later on as to what you may be seeking. Bench warrants, it's possible under the act. I've not seen a court issue a bench warrant for someone failing to show up for a civil infraction. Technically, it's actually a crime not to show up for a municipal or for a regular traffic civil infraction hearing, but then you have to have additional information such as the person's date of birth and their driver's license, and the prosecutor and the courts are not going to issue warrants even for that type of violation. So that's an example of actual discretion that a prosecutor has as well. So bench warrants, haven't seen it happen. It's possible though. So the penalties are under the Judicature Act, which is the MCL 600, specific under 8701C. You can have fines of up to $500. You can have a fine schedule. My recommendation is to still have the penalty as a fine up to $500. If a municipality wants to have a fine schedule, they can create that by resolution. Some ordinances put it directly in there, but then you have to amend the ordinance if you're going to change that. So I prefer just to have the, up to the limit of $500. There's also costs of prosecution. Generally under the Judicature Act, that is limited in certain circumstances to $500. There are ways, to get around that, but that's normally what is done, and the courts do not like to have excessive, fines and costs assessed against violators. So on the service side, which we'll talk about in the next slide here, this also mentions the option, which I don't recommend to almost any municipality up here. Maybe perhaps Traverse City has one, and that's having a municipal ordinance violations bureau. Again, if you have ordinances and your ordinance book is 2-3+ inches thick, and you have a plethora of ordinances, many larger municipalities will have an ordinance bureau. They will take the fines then internally, because normally a fine at a civil infraction, the municipality keeps 1/3. The balance of it goes to the library fund. I think that's the same as the traffic civil infraction. But with the bureau, the municipality can keep, all the fines and go forward that way. It does not provide for any injunctive relief. So even if you have a bureau, you still, if you're seeking injunctive relief, you still have to go through the formal hearing process and get that order from the district judge. Otherwise, people can simply pay the fines. And frankly, if you don't ask for a formal hearing, a defendant who simply wants to pay the ticket can run to the district court after the ticket's issued if you don't get your notice in requesting a formal hearing and pay the ticket. And then you have to start the process all over again. So I'll talk about that a little bit more, as why it's important that if you're going to pursue these, probably a formal hearing in most cases is the way to go. Service. Service can be by personal service. The ticket has a spot on there. There's several copies. You have a defendant copy, you have a copy for the municipality, you have a court copy, and usually an extra copy. And I recommend even making a photograph on top of the once the ticket's filled out, so you have even additional copies for the zoning administrator or code enforcement officer. Service can also be by posting and by mail. The mail does not have to be return receipt. It's simply first-class mail. I do recommend that the code enforcement officer or the zoning administrator put in what's called a proof of mailing and keep an extra copy, stating that on a particular day, they mailed a copy of the ticket to the defendant on X date with that form. So that'll be available later, for the court to know that the ticket was properly served. And posting, never put the ticket inside a mailbox. There are federal laws regarding that, but you can post it on a tree in front of the property, along the road right of way, or on a post or telephone post. If if the relationship has been okay and, with the property owner, between the property owner and the zoning administrator, you could post it on the front door. But if you're told, or the zoning administrator is told by the property owner, I don't want you, on the property, you have to adhere to that. And I'll talk outside of the slides a little bit about how those items sometimes can be addressed. If you don't follow the rules though of proper service, that is basis for the court to dismiss the case, and you will not get to the formal hearing. If the zoning administrator thinks the situation's, somewhat volatile, you can always request, law enforcement or a deputy to assist the zoning administrator or code enforcement officer to post the ticket or do personal service, whatever works as well. We want everybody to keep safe. That's not just the zoning administrator and the code enforcement officer, but for the safety of the occupant or property owner as well. So injunctive relief, that's what's called equitable authority for district courts to enforce under the Judicature Act. Yes, there's an imposition of a fine of up to $500. Yes, there's a cost of prosecution, which can include attorney fees, generally up to $500. Liens generally don't occur until you get the final order stating, I'm going to use an example of a nuisance ordinance. If the property doesn't end up getting cleaned up, you can ask the court to issue an order allowing the township to hire a contractor up to the jurisdictional limit of the district court, being $25,000, to come onto the property, clean up the property, of the junk and nuisance, and bring it into compliance with the ordinance. And then the property ends up getting liened, but through the Real Property Tax Act. So the statute under the Judicature Act allows those fines to be added to the person's property taxes. And if it's not paid, at least the following year, I know there's a 3-year process, of course, if you don't pay your taxes, the county will generally step in and reimburse the township or the village for the costs of the unpaid taxes. So the township tends to get their money back pretty quick, within a year, when you have to go into those extreme situations where you're going into the property to try and, or not to try to, but to rectify the violation if it's not being done by the defendant. And that includes orders of compliance and abatement. And then, at the end, I'll go through really the entire process as a recap here. The order also contains general provision stating that if you violate the order in the future, I'm going to come back and enforce the order again. If it's years later, I don't recommend that. All right. The property may have been, let's say it was a nuisance violation where junk had been cleaned up, and then the same property owner, but the nuisance comes back, more items are accumulating in violation of the ordinance. That's really, you should just start the process over if it's several years later. Courts don't like to look at old orders, and after 5 years, if you don't renew the judgment, it goes into a sort of what we call hibernation there. It's not enforceable except by bringing it up by motion, and after 10 years, it's generally gone. All right, so here's the core of the question: civil infraction or misdemeanor? In the beginning, ordinances were prosecuted as criminal misdemeanors until the civil infraction option became viable under the Judicature Act. And now, as I mentioned before, almost every municipality has municipal civil infractions. They're faster. You still have due process because you have the district court judge, you have the right of appeal, but you also have less expense and time in the court. The courts are a little slower than they used to be pre-pandemic. So even I've noticed in the 86th District Court, we used to get hearing dates within 3 to 4 weeks after the ticket has been filed and a request for a formal hearing has been filed. Now it can be up to a couple of months. Things have just slowed down, a little bit for whatever reason. Now you can do it through a general municipal civil infraction ordinance. My recommendation for a small rural township like Whitewater Township is to have the penalty, for example, in the zoning ordinance, have the penalty section for civil infractions in the zoning ordinance itself and within the various police power ordinances that you have. And it may be a good time, for the township, and that should be done by every township every few years. Take a look at your police power ordinances. Which ones have you really used? Which ones do you really want to enforce? Which ones do you want to get rid of? Which ones do you wish to add? All right, that's something you look at every once in a while. I think every municipality does that. And of course, part of that has to do with the desire of, of the board based upon the desire of the electors of the township. So I mentioned Central Lake Township before. Nothing, no zoning ordinance, no police power ordinances. I mean, you have choices there. So this goes over once again the difference between the misdemeanor criminal penalty. Again, it's not recommended to make ordinance violations a crime. It's just really not in that category. Again, you have the burden of proof, guilty, not guilty, beyond a reasonable doubt. The penalty could include jail, which is not desirable under any type of circumstance. Somebody sitting in jail is not going to be able to rectify their zoning violation or their police power violation. It gets prosecuted into the district court because it's a misdemeanor, not a felony, no circuit court action. The defendant would be entitled to an attorney at public expense if they meet the income requirements. And of course, we have the jury trial at public expense, although quite often, nowadays if a defendant gets convicted, they'll add a jury fee, as part of the penalty if you're convicted for a violation or convicted of a crime, whether it's a misdemeanor or a felony. Civil infraction, there's the outline again. The preponderance of the evidence is the standard. If there's more evidence showing a violation than not, that's what preponderance means, and the court will then find that the violation has occurred. Frankly, when I do prosecute civil infractions, or when I did criminal work, you go in with overwhelming evidence. All right, you should not go into court unprepared with marginal evidence ever. And so I don't really care whether it is a misdemeanor or beyond a reasonable doubt, or whether we have a civil infraction. I endorse the civil infraction because I think it's a more responsible and better process here. But either way, when you go to court, the attorney best be prepared to prove it even beyond a reasonable doubt, even for a municipal civil infraction. There's no jail penalty, which is appropriate. Only, the attorneys are only allowed in formal hearings. We've already talked about that, not informal. No attorney appointed by public expense, but certainly defendants are welcome to hire their own attorney to handle a formal hearing. And there's no jury trial, but again, the appellate rights, appealing to the circuit court and up still remain. So civil infraction, I don't even know if I need to go over this one more time here, but it is really the best process, the most cost-effective process for the municipality. It makes a lot of sense. And frankly, if you have a criminal penalty, most municipalities are loath to go, the ones that I've heard of in the past to prosecute that. I understand that you have, a case that's currently pending in Whitewater Township, which has been ongoing for quite some time. It's very difficult. And frankly, my advice would be is if you keep a criminal penalty, you might as well just get rid of the ordinance, because the burden is so, and the cost is so onerous that it really dissuades the municipality from enforcing their ordinance. And if you're not going to enforce the ordinance, you probably shouldn't have the ordinance to begin with. All right. So what is the process? We have the zoning administrator here. You have a very experienced one, Deb here. I know her very well from other townships in the past here. A good zoning administrator will go and talk to the property owner, alert them, of the violation, discuss, remedies and timeframes for being able to correct the violation, whether it's a zoning or a police power type of ordinance. If it doesn't work out and after repeated, contact one or two times and going on the property with timeframes where things were supposed to be done, a letter is then usually issued with the zoning administrator or code enforcement officer outlining their previous discussions with the property owner, stating, here's what, needs to be done. Can you please get back with me and give me a time frame of when you're going to be able to complete this and bring your property into compliance. If all of that fails, then the last resort is to issue the civil infraction citation. You can prosecute as an informal. I recommend that if you're at that point, always ask for a formal hearing. Because otherwise, again, you can't get the injunctive relief and you can't get the order that requires the defendant to comply with the ordinance, which is the object of the whole of having the ordinance to begin with. And then, of course, that would be enforced. Now, I talked about getting the order where the township could, at township expense, then lien the property, go onto the property and rectify the problem, whether it's junk or complying with the zoning ordinance as well. The Judicature Act actually has a procedure where if somebody says, I'm just not going to do anything, regardless of that, and you don't follow that procedure, it's possible for the court to find the person in civil contempt. And it actually has an old part of the statute where you could jail somebody for up to 30 days for civil contempt, and then they get a credit of $30 a day on the fine. That's been sitting in the books for several years now. It's never invoked. Nobody does it, but it's there. Yeah, again, the ultimate goal is compliance, not punishment. This is not a revenue generating feature. Even municipalities that have a bureau, they're not there to make money. They're there to recoup the costs associated with ordinance enforcement. You get part of that, but don't expect to get everything back. The idea is to simply get compliance and make sure that the community is protected, their health, safety, and welfare under the ordinance, because that's why it was passed. But always getting voluntary compliance is always less costly. And that can be done, even all the way up to the hearing date. It's not uncommon, and I urge municipalities to provide that type of freedom to make decisions on the part of the zoning administrator to say, hey, we're at the formal hearing process here. The court's going to require the attorney and the defendant or the defendant's attorney to talk to each other almost always before they proceed with the formal hearing. Hopefully they've done that before if it's the other attorney, but quite often when I'm in these hearings, the first time I get to see the defendant is on the morning or the afternoon of the hearing. And what we can do is we can say, look, we got to this point here now. All we're seeking is compliance, and you have the ability with the zoning administrator's authority to do so. Say, look, we'll enter an order. You're responsible for violating the ordinance. Here's the injunctive relief. Hey, it's winter time. It's January. We know that cleaning up your property in the next 3 months is not something that's doable. Can we have an order stating that this will be cleaned up by July 1st? I'm just throwing that out there as an example. And if you do that, then the fines and costs of prosecution are waived. We notify the court. The property is cleaned up. Yes, you spent money on the procedure. No, you didn't get any fines and costs, but you got compliance with the ordinance without expense on the part of the defendant, because we prefer to have the defendant, the person found responsible, to use their money not to pay fines and costs, but to get a contractor or do what's necessary to bring the property into compliance. So that can be done all the way through the order process. Okay. Now, if the order is not followed, then of course those fines and costs can come back in. And again, you may see the defendant would see a motion for civil contempt and another court order requiring or allowing the municipality to go in and rectify the ordinance and lien the property on the taxes. This is the slide again about the letters, and I don't even like to call it a warning letter. I know the slide has it on there, but it's really a letter on the part of the zoning administration saying, look, we've talked about this. Here's what the ordinance says. Here's the violation. Here's what your situation is. You said you were going to clean it up, or no, I haven't heard from you, or whatever the situation may have been between whatever contact the zoning administrator or code enforcement officer had. So here's your timeline. We don't want to issue a ticket. If we have to, we will. All of that gets put in the letter, and that's important information. A copy of that, if we end up in court, you can present that as a piece of evidence, to the court, saying, look, Judge, we've tried to work this through. We didn't want to come to court here. We wanted to get this done without having to go to court. We weren't successful. Here are the steps that we took, and that would be part of, what's presented by the township attorney, as well as the zoning administrator. So I did provide, I think, earlier when I started representing Whitewater Township, an outline of how a ticket should be filled out, at least for purposes of the 86th District Court. You have to pay attention to the court you're in. Charlevoix has a different procedure that they've had in place since 1997. Crawford County has a slightly different procedure. Every court is somewhat different. So as long as you're following what the court wants and your citations correctly filled out, you're good to go. If a code enforcement officer or zoning administrator is unsure because they're new or haven't filled out tickets before, I always recommend that they make a photocopy of the ticket, do a dry run on filling it out, and then send it to me for review, just to make sure that ticket is correct. Anything that's wrong, I'll assist in correcting it so that the final product is good and we don't have to file a motion to amend the ticket or do anything of that nature. Again, proper service, either personal service or posting and mailing, with the proof of mailing affidavit that's kept by the zoning administrator as part of the file. File with the district court. We would then coordinate that with the court and they will set a hearing date. If someone's on vacation, if the defendant's gone, the zoning administrator is on vacation, we can always, move the court date. Court's usually pretty flexible about doing that. So, all right. Informal hearing. This is just a repeat and a summary again here. Again, I don't recommend informal hearings. You're not going to get to the goal post, so to speak, to the goal line here on getting compliance with the ordinance in almost every situation. That's why the tickets are to be issued only when you absolutely have to, but when you do have to, you want to make sure that you get that relief and get that compliance, and you're not going to get the compliance with the informal hearing. Formal hearing, again, preponderance of the evidence. I have to be there, or your township attorney has to be there. In the 86th District Court, almost every, I think they've gone completely to Zoom for every municipal civil infraction hearing. Other counties don't allow it at all, so it depends on where you're at, which district you're in. But I know that both Judge Stepka and Cooney, all of them are done by Zoom, and quite often they don't even, if the case is in Antrim County, they'll be hearing it, in their offices in Traverse City. So you should be prepared for that. I generally make sure my evidence in the form of any exhibits is sent out in advance to both the defendant or the defendant's attorney, as well as to the court and the township, so that when we, show up at the hearing, they can enter that automatically based upon exhibits that the court already has. And again, the object is the complete relief, and it may not be again the imposition of the fine. If you have a consent judgment or a judgment where, hey, we're going to modify this and not hit you with fines and costs there because we want you to to comply with the ordinance, then that'll be the first part of the order. All right, but as things progress, even after you get the judgment, if we have to come back and ask for civil contempt, then of course all that gets added back in, and additional fines and costs are then assessed. And normally, if you're in the civil contempt stage, that's where after that order, the municipality would have the option, not the obligation. Okay, it's an option to make the decision of whether to go in there and clean up the property or otherwise rectify the violation on the property owner pursuant to a court order. And then, of course, up to $25,000 jurisdiction gets placed on the taxes. The order would also include a right to inspect the property afterward and make sure that it's cleaned up, even if we're not proceeding with civil contempt. The defendant may say, hey, I met the requirements under this consent judgment. I shouldn't have to pay the fines and costs. So the order would allow then the zoning administrator or code enforcement officer to come onto the property and then verify that the property has been brought into compliance with the ordinance. We notify the court and the matter is completed in those situations. All right, so the township, and that's part of what you're also looking at is the process here. It's a little little small on the screen here as far as the enforcement process here. But again, it begins with contact with the code enforcement officer and the zoning administrator once a complaint has been received. Sometimes the zoning administrator may notice a violation on their own, but most rural townships are not putting people in cars and with badges saying I'm the zoning administrator, looking for a violation. It generally doesn't happen in rural townships. Most of them are generally complaint driven. And sometimes you'll get, then if it's complaint driven, and the zoning administrator goes out there, the defendant may say, well, how come, you're coming after me? Bob down the street has the same thing. Well, then the zoning administrator would go and check on Bob down the street to see whether that's the case. I mean, sometimes these things, happen in that manner. All right. And after contact, then the letter would end up going out. And, the process is a slow walk process all the way through to the point where you go to a formal hearing and obtain the order, again, being the last resort on here. Let me take a look and read this one a little bit better. And hopefully most cases it's resolved. Of course, the zoning administrator may get a complaint that's not viable, saying, no, this person's not in violation of the zoning ordinance. They're not in violation of this nuisance ordinance. They'll notify the complainant that the person's in compliance with the ordinance, and the matter gets closed at that point, or gets closed after resolution from, through discussions and through meetings between the zoning administrator and the property owner. The compliance agreement, the proof should be in the pudding on that it's done, but you can have an agreement, and then if it's violated and said, look, you signed off and said you're going to get this done by X date. Now we're going to go to a formal hearing. That's an additional piece of evidence that you could bring in for the formal hearing process, saying, look, we already thought we had this resolved. Even contractually judge, I'm sorry that we're here, but you get to the point where once the ticket's issued, that we have to proceed. And again, hopefully even after the ticket, you can have compliance that occurs before the formal hearing. So let's say you have the ticket and then the property says owner, ends up cleaning up the property or corrects the zoning violation. Then you have the option to dismiss it. And it's just dismissed and the hearing never happens and there's no judgment and you're done even before that, before you end up in the court. So that's a possibility as well. But ultimately, once compliance is obtained, whether through a consent judgment, default judgment, or judgment after hearing, and if there has to be a civil contempt motion where the township then comes in and cleans it up, that's how the cases are ultimately closed, in the most extreme sense. I don't really have a statistic. I don't know what the percentages are of violations that are cured. You probably know that internally in the township, through the zoning administrator. I'm sure that most situations in many townships and municipalities are handled and closed out long before any ticket is issued, much less any court hearing. It depends on the municipality, and also depends on how new is the ordinance, how much enforcement has occurred in the past. Is enforcement now more of a priority? Enforcement should be a priority because, again, you have your ordinances. If you don't want to enforce the ordinance, you probably shouldn't have the ordinance to begin with. So what we talked about, the police power versus the zoning authority, that's the difference between the grandfathering or non-conforming use under a zoning ordinance. Police power, no such thing as grandfathering in. I discussed the criminal. There's really no reason to have an ordinance violation as a criminal case. Civil infraction makes a lot more sense. It's easier on all the parties involved, and it still preserves the due process rights of appeal all the way up the line. Progressive enforcement, that means you're just trying to solve this issue before you end up going to court. And that's why you had in the previous graphic there, the outline as to all the steps that are taken before you end up having a hearing and before you end up having to get a judgment on the violation for someone being responsible for a civil infraction. So voluntary compliance is always the goal. So I don't know if the board has any further questions.
So the
opportunity for due process with this exists. First, it would go start at the magistrate if it's
an informal hearing.
formal.
Yeah.
But you have the opportunity to go to a judge, but there's no opportunity to request a jury trial. Is that correct?
That's correct.
Okay.
Yes. But there's, when you appeal even a conviction after a jury trial or after a civil jury trial, the appellate process doesn't involve the jury anymore. So all those procedures, the ability to appeal the outcome, are the same with the jury trial as they are for a civil infraction, as you go up the line. So your next step will be at the circuit court. Circuit court would review the record and on the appeal. I think it's only by leave after the circuit court for a civil infraction to the Court of Appeals. So they may decide, yes, we're going to hear it, or no, we're not going to hear it. So in those situations.
Thank you.
I have a question. Would you mind clarifying a little bit in more detail about things that are grandfathered in and not? So we're, if I'm understanding you right, we're under police power right now because we have a misdemeanor or a civil, oh my gosh, I'm sorry, I'm so tired.
It's actually the difference
So-
between the zoning, really the difference on the grandfathering and non-grandfathering is the zoning ordinance has the grandfathering. So for example, if you didn't have a zoning ordinance and you had, a slaughterhouse, all right, and you zone that district residential, the slaughterhouse can remain as a lawful non-conforming use until it's been abandoned. They can't expand operations. They have to maintain the operations as they are until operations cease voluntarily. But with junk, I mean, I've seen junk type of nuisance ordinances or junk provisions inserted in a zoning ordinance, which I don't recommend, at all. Because by putting it in the zoning ordinance, then the junk becomes a lawful non-conforming use on that property. That is not the case with a police power ordinance. Once you pass it, if the nuisance, dilapidated building, inoperable motor vehicle, whatever the case may be, once that ordinance is passed, even if they didn't have an ordinance before, you have a right to enforce that ordinance and the property owner has to comply with that ordinance. So that's the difference between grandfathering and not grandfathering. And the grandfathering is a zoning concept.
So for example, and I'm just making this up, but if in our zoning, we had somebody build a 7.5-foot fence 30 years ago and nobody's ever complained about it, and then we adopt a civil infraction ordinance, it can now they would be forced to take the 7-foot fence down just because we have this ordinance, or does somebody still need to complain about it? I mean, how does something that's been going on for years and years and years and allowed, even though it may not be defined, or maybe it is defined in our zoning ordinance, but do you
It
get
would
what I'm saying? Like
Sure, no, I understand.
some
Yeah.
of these things have been going on for a long time and they've never been enforced.
They should be defined, okay? So if you have a fence regulation, all right, maybe it didn't come to the attention for years, okay? The general law on that, even if you had years and years of nobody enforcing a zoning ordinance, but you did something that was not allowed under zoning 10, 15 years ago and it gets discovered, you don't have what are called, you don't have any equity in that, all right? You have what are called under the law unclean hands, all right? You actually received a benefit by being able to do something you were forbidden to do until you were discovered. So you can't come back and say, well, wait a minute, I've had this forever, I should be able to keep it. That's not the case. So yes, the enforcement would be the same, whether it was discovered with a criminal penalty and you decided to go after someone with a criminal penalty, which, for reasons I've already discussed, I don't recommend, or whether you change to a civil infraction, it doesn't change the nature of the decision to enforce it. Now, if you've had some townships have not done any enforcement for anything, okay? They may have ordinances on the book and they've never taken any type of enforcement action for decades. If you're in a municipality that has a situation like that, we usually recommend that the township take a look at those ordinances and generally pass a resolution saying, in the past, we really didn't, we had these ordinances, we didn't take action to enforce them, whether complaint driven or otherwise. Henceforth, we're going to take those type of actions. And that sort of brings you back into the fold of the courts so that you don't show up in front of the judge and say, well, we knew about this for 30 years, but we're deciding to enforce it now. That usually doesn't go over very well in court for obvious reasons. So that can be a problem for extremely long violations if those violations were known by the township or officials, including previously elected officials and administrative staff.
A question, can you, I think I know the answer, but can you describe again where in the process, in the formal process, a fee or a fine might be levied? Is that at the conclusion of it? Is that earlier, or can you just describe that
No,
more completely?
the fine would not be done or handled or assessed until you have a person found responsible either at the informal civil infraction hearing or at the formal hearing. And even then, I described that you have some flexibility to decide if it's a consent judgment or for other reasons. Look, we're not going to issue a fine right now. We want you to, note that you're responsible for the violation. We need this violation cured by X date. However, if you don't fix that violation by X date, then we are going to assess the fine of $500 and cost of prosecution of $500 and then,
Up to
and then
500.
up to, and then move forward from there. Yes. And those amounts, including any final order that allows the township to come in onto the property and rectify the violation, would be added. Those costs and expenses, the fines and costs that are unpaid would be added to that figure as well.
Follow-up question on that, though?
Go ahead.
So who's determining or recommending the dollar amount up to 500? Is it the zoning administrator? Is it the magistrate, the judge?
The judge will, if you say $500 and unless you provided the judge with a fine schedule, if you wanted to have one, that's, the judge will issue that fine, okay, and that amount there. But the court is very flexible because you're prosecuting and the township attorney is acting as a prosecutor. You have prosecutorial discretion, all right, on what you're assessing there. And as a prosecutor, I saw that all the time, all right? And we did that as well for people. Judge, we don't think, the full costs or these expenses, are right. Or yes, we agree that this person should have work release, even though they're convicted of a crime and are sentenced to 6 months in the county jail so that they can, pay their fines and continue supporting their family and so forth. There's all sorts of discretionary ability to move. But you're correct. If it's fixed and you're saying, all right, I just want, we want a $500 fine, want $500 costs of prosecution, $1,000, and you've proven the violation, the court will generally give that to you.
Peter, can you please clarify, as we go on to the business portion of this meeting to look at some motions, the language that we're adopting or proposing to adopt as far as civil infraction says a fine of not more than $500. And then it's appended by another sentence that says every day that such a violation continues shall constitute a separate and distinct offense under the provisions of the ordinance. You explain to us exactly how that is utilized.
Yeah, I mean, there's very few cases that have talked about it. And being sort of a smart aleck out of the prosecutor's office, when I started doing this work for municipalities in 1999, I actually made that argument in front of the district judges here in the 86th District Court, and it was quickly taken down by the judge for even, suggesting that. It's not done, at a particular hearing. Remember, I talked about earlier that if you have a judgment and the property was cleaned up, let's say it was a nuisance ordinance, and then later on the same property owner is accumulated or engaged in the same violation, the same ordinance, that's where you'd start the process over again and then issue a new municipal civil infraction. The law allows you to do this, but the courts don't, okay? The courts will quickly come after any municipal attorney trying to say, all right, judge, I want, $500 a day every day here until this is done. Never happens. I wouldn't even ask for it because I know what would happen if I asked for it. It's not done. Is it a part of the law? It's part of the old common law. There's actually a case from 1990 out of Detroit, and it had the same type of penalty, and the court stated that, yeah, it's allowed. Defendant does not exceed its statutory authority. In this case, it was someone who sued the city of Detroit to punish for violations of its point. This was a point of sale ordinance by providing that each day of violation constitutes a separate offense. So does the law technically state that it does? Yes. Is it in practice done? No.
Is it necessary for that clause to remain?
You could take it out because ultimately you could issue, any type of, you would be able to issue another violation later on. But when we prosecute these violations, I make sure that the photographs and the evidence match the date of the ticket when it was issued, because you want your evidence to match the date of the violation on the ticket there. I may show photographs later on saying, Judge, even after all this time, and we tried, since even issuing the ticket and asking for the formal hearing, we still haven't gotten anywhere. So here are the pictures from the date of the violation. Here are the pictures as of, yesterday or last week or whenever the zoning administrator took those photographs. But I'm not asking the court to go and issue another, a series of fines and costs from X date to Y date. That doesn't happen and wouldn't be allowed.
Okay, any other questions from the board at this point?
Well,
All right.
my understanding was the language about what you just described was that if there was any other part of the ordinance that was violated, that the violation would still, there could be another fine for some other part of the ordinance being violated. But you're saying we could just simply take that out.
Well, in a police power ordinance, yes, you'd issue a new ticket anyhow. Let's say it's a zoning ordinance, right? You have a zoning violation because someone didn't get a permit and built a structure within the setback. And then you discover after the ticket's issued that the structure is too high, all right? And doesn't meet the height requirements of the ordinance. That's a second ticket regardless, right? It's a separate violation but of a different part of the zoning ordinance. On junk and nuisance ordinances, that generally doesn't happen because junk is junk and a dangerous structure is a dangerous structure. It may have different reasons as to why it's dangerous, but once you cross that threshold, the violation remains the same all the way through. So it's better probably to keep it in the zoning ordinance. It's not as necessary in the police power ordinances.
I'm sorry, did I hear you say that the everyday provision should be in?
I would keep it in the zoning
the
ordinance,
zoning,
yes.
okay. So if a building is built under the zoning ordinance and it didn't get a permit and there's a process, wouldn't the relief be to have that building removed or made otherwise to comply versus a $500 fine?
Yes, in addition to that, that would be part of the order, but that's where it depends on whether the cost of doing so is within the jurisdictional limit of the district court. I did a couple of cases in East Bay Charter Township where I had to go to circuit court because the cost and expense, I had to order someone to take down their entire garage. This was a very expensive garage in the Lakes area district there. But the court, granted that relief and he had to remove a structure that was probably cost well over $100,000 to build.
I'm sure that was a last resort, though.
It was, yeah. We tried to see if we could do voluntary compliance. We hired attorneys and that was his right to go to hearing and that was a full-blown circuit court case. So there was discovery, there was interrogatories. It was fairly expensive on the part of the township to have to prosecute that, but they didn't have a choice because the amount of money involved in getting compliance exceeded what you could do in the district court. Could you do it in the district court for something under 25,000 if they got to shave a corner off a building or get rid of an overhang? Yes, you could. Well, options, there's always the option under zoning on dimensional requirements to get a variance, all right? But zoning administrator should be realistic with the defendant, given the standards for obtaining a variance are very high and generally are not granted, what their chances are for doing so. But that's an option. You never know. They can always go first to the ZBA.
Wouldn't that be part of the effort to have administrative relief versus going through a civil infraction mechanism? I mean, if you.
It's not a requirement of administrative relief on there. You can offer that as an option, but it doesn't preclude the municipality from issuing a ticket for the violation, through the zoning administrator. And generally, most ordinances will have zoning ordinances will state in there that, a disagreement or an appeal of a zoning administrator's decision does not forego the ability of the zoning administrator to issue a ticket and proceed with the case, regardless of that.
I have one last question.
All right, this will be the last one. We need to move on to public comment. We've been waiting quite a while.
So I think we understand as a township how a civil infraction would benefit the township administration of enforcing our ordinances. It's faster, it's cheaper, it's easier. How do we sell this to the public? Because what's in it for them that makes this better for them? Under the MCL, it still looks like they can be arrested, put in jail, pay heavy fines and costs. They can have a lien put on their house. I mean, it's not really any friendlier.
Well, it is. I mean, it's
So-
not a criminal violation. Okay. So they're not going to be thrown in jail. I use the one extreme item there where if there's a possible civil contempt, you could be up to 30 days. Never seen it invoked. Haven't seen a judge ever do that. So generally, no. Criminal penalty, that's one of the primary penalties on there. The other item is look at your ordinances, all right? Look at the reason behind them, the expense of its enforcement. If you try and hamstring or tie yourself up into a criminal procedure instead of a civil infraction, then you have to question, why do we have this ordinance? If we're trying to restrict our ability to go ahead and enforce the zoning ordinance or to enforce this police power ordinance, do we as a township, should we have this to begin with? Because if you put up a blockade, have passed an ordinance, and then make things much more difficult for you to proceed in its enforcement, that may not be an honest position to take with your electors by saying, well, we have these rules and regulations here, but it's so difficult to enforce, we're not going to do it. We hope you voluntarily comply with it. And after a while, it's not going to happen. And then,
Thank you.
Okay, so at this point, we're going to move on to public comment. I would like to review the guidelines. The lawyer provides answers to the board. You can come up and make a public comment, and then the board will decide if we want to proceed to have the lawyer address that concern. Excuse me, yes, we all pay him. So at this time, I have the floor. So I'm going to explain the public comment rules. I know there's lots of people here that would like to have some time to express their feelings on this. So comments are directed to the board right here. You're talking to us. You will speak from the lectern. We ask that you provide your name and address, and we've provided forms so that you don't have to stand up there and recite and spell things for our secretary, Kay. So if you can fill that out ahead, it'll help things move along. You may address the board on matters that are relevant to township business. The amount of time that will be allowed tonight based on the size of the crowd will be 2 minutes per person. It will be timed. Excuse me, this went done. So, excuse me, you will be given 2 minutes at the discretion of the chair under the circumstances. You will all get a chance. These will be timed. Excuse me. If you are disruptive, you will have to leave. So everybody will receive an equitable amount of time. There is a timer. Wendy will be running the timer. So if you do hear that timer, we would ask that you quickly wrap things up, please. And then the last thing is you can speak one time, and any additional conversations, we ask you to please keep that down. If you want to have a conversation, please step outside the meeting room so that the speaker may be heard. So now the first person may step forward to the podium.
Heidi Baummuth, 8388 Winnie Lane. Dear Township Board members and Township Attorney, the question before us tonight is really very simple. Does Whitewater Township need an effective way to enforce the ordinances that already exist? I believe the answer is yes, because the need outweighs the want. Some residents have said they don't want a civil infraction ordinance because they don't want zoning enforcement. But wanting fewer rules doesn't change the fact that Whitewater Township is and has long been a zone community. The voters and elected officials made that choice to protect the health, safety, welfare, and character of our neighborhoods. We are a zone community because zoning protects us from ourselves. It creates reasonable standards so that one property owner's choices don't negatively impact their neighbors or the community as a whole. Without enforcement, ordinances become optional, and those who follow the rules are placed at a disadvantage compared to those who don't. A civil infraction ordinance doesn't create a single new zoning regulation. It simply gives the township a civil process to enforce the ordinances that are already on the books. It provides due process while avoiding criminal penalties for most violations. It isn't something unique or to argue about. The vast majority of Michigan townships use civil infractions to enforce their local ordinances. Here in our region, neighboring townships such as Garfield, Acme, Blair, East Bay, Elmwood, Clearwater, Fife Lake, Leland, Peninsula, Long Lake, and Milton all have civil enforcement in place because they recognize that education should come first. But there also has to be accountability when voluntary compliance fails. This discussion isn't about taking away anyone's property rights. It's about ensuring that the same rules apply equally to everyone. That's what good government looks like, and that's why I encourage the board to adopt a civil infraction ordinance. Have a nice evening.
Thank you for your comment. Who would like to be next?
Hi, Denise Idish, 9276 Elk Lake Trail, Williamsburg, Michigan. I don't understand how we can make this a criminal offense. I own my property. I pay my property. I pay the mortgage. I pay the utilities. I pay the property taxes. I do the maintenance. I do everything. And I don't see how we're making this pure Michigan, because it's pure bullshit, actually. Excuse my language. And I've never been offered a vote on any ordinance. And I have never offered Deb Gran the right to protrude on my property, but she has. And this grandfathered in thing, I'm not really sure about it. I'm not an attorney. I don't know. But I should be able to protect my rights, my property. I have never, it's just, there's been, okay, I never even got a zoning notice. Like, okay, here, we're gonna have a zoning hearing. Nope, never got that. But no, you said there's no criminal hearing? Yeah, I was in jail for a day. So, yeah, I mean, I am a criminal. Look at me. No, I'm not. I just have a property that I have paid for and I maintain and I utilize, and I don't understand why I am being prosecuted, persecuted, and thrown in jail. That is outrageous. It's ridiculous. It's insane. But you know what? If you really need to throw me in jail, I guess I should be thrown in jail. Put the handcuffs on.
Thank you. Who would like to be next?
I'm sorry. Did I cut? Hello, my name is Michelle, and I'm here to express my concerns regarding the board's plan to implement civil infraction enforcement on zoning issues. I typically remain quiet at township meetings. I prefer to keep a low profile and mind my own business. However, recent experiences have compelled me to speak out. I have gained firsthand experience with our zoning process. While our current system may not be perfect, it has various checks and balances. After moving some items and filing the necessary paperwork, I thought the issue was resolved, but that was not the case. I'm speaking up tonight because my family has faced unprofessional behavior from officials who have treated us as if we are public enemy number one, based on inaccurate assumptions and biased information. Just this last Monday morning, I thought this issue that I had been diligently working on, stemming from April, was behind us. But then I received an email stating that the township now wants to inspect what is factually landscaping, yet is now perceived to not be so. I find this surprising, disappointing, and disrespectful. Hiring a property rights attorney should be entirely unnecessary in this situation. It is extreme, yet I feel compelled to take this step to protect my rights, as I fear that my property will never be viewed as good enough. by others. Unfortunately, I've been forced to hire a professional to safeguard my interest and to filter all communication. I share this experience as a cautionary tale to my neighbors, a potential warning of what's to come. The thought of a civil infraction ordinance being placed is alarming. A neighbor and I calculated that under this ordinance, my current bill could exceed $15,000 and continue to grow.
Michelle, if you can wrap it up, please.
Yes, ma'am. As a clinical master social worker and a mental health professional, I've observed these thoughts, feelings, and behaviors in this process that are unhealthy. The situation jeopardizes not only my well-being, but also that of my family, my neighbors, and our community,
Michelle.
posing risk to our physical and emotional financial health. One paragraph. This policy change moves us farther away from the
Michelle,
rural character
you need to wrap
and
it up.
values. Yes, ma'am. Resident cherishes. I urge you to reconsider. It is essential that we preserve our rights.
Your
and our
time is
foster-
up and it is unfair to others who are waiting. Please
ma'am.
step aside now.
Yes.
You,
Yes.
you may email us the detailed comments. I've received your email in the past. The entire board receives it. Thank you. Ron, please step forward.
Thank you, everyone.
Ron Backey, 6987 Cook Road, Williamsburg, Michigan. 2 minutes. Wow. This was uncomfortable. I felt uncomfortable with that lawyer up here talking about how they're gonna prosecute my fellow neighbors. That was really bad. I feel sick to my stomach. I feel sick for these people. These are my neighbors. These are my Whitewater Township people. And this civil infraction, not a good thing, not a good fit for our community. Why are we even here? Didn't we do this at Mill Creek not too long ago on an 8-2? I mean, 80% of the people said no. You work for us. We don't work for you. You need to listen, okay? I had every one of you guys in my front yard and you're letting me down. You're letting our community down. You know, Whitewater Township's a gem for a reason, right? If it ain't broke, don't fix it. There are 3 ordinances you're gonna destroy this township with. The wine and tasting ordinance, AKA event barn ordinance, the weekly rental, and the civil infraction. Are you kidding me? This township, our property values are going up. Why do we need to change? Whitewater Township's a 65 Mustang handed to you. The keys were handed to you. All you got to do is change the oil, air the tires, wash the car, and move on. You don't need to create ordinances that destroy the township. Sometimes not creating an ordinance is doing your job, right? So we need to, our neighbors, I was deputy supervisor for a small stint under Ron Pop, and he said one thing to me that really stuck. He said, you need to put yourself in other people's shoes. In a township board, you need to wear a lot of shoes, right? In a planning commission, you need to wear a lot of shoes. How does that other person feel that you're giving a $500 ticket to? Maybe the person next to him can manage it. This is disgusting. I'm done.
Howdy. Jessica Mangus, 5101 Brown Bear Lane. I wanted to point out one quick note myself and then read the second half of Michelle's public comment that she had prepared for the 5-minute limit. Just real quick, you mentioned,
Excuse me,
Yes.
Jessica, it is 2 minutes equal to what everybody is given tonight.
I am aware, I was informed it was 5. I guess that rumor had spread around, so some people had must have prepared for it. But anyways, I can keep it under 2. I did want to mention that you mentioned earlier how the feelings of the community were going to come out. I think this is feedback, and those things are very different. You can kind of discard or cloud out feelings, but feedback is essential to the process that you're following here. That said, to pick up where she left off, this policy change moves us further away from the rural character and values that residents cherish. I urge you to reconsider, as it is essential that we preserve our rights and foster mature, respectful dialogue where everyone can be heard and engaged in productive problem solving. It is crucial that we maintain the ability to live peacefully in our community, free from fear. You all need to hear this quote and remember it. Ah, Michelle, I have learned a valuable lesson. Next time, I will not be as helpful. I will let people figure it out themselves. Thank you for your consideration of my perspective and Michelle's perspective and all of our perspectives.
All right, thank you, Jessica.
Good evening, Ron Pop, 6237 Elkview Drive, Williamsburg, Michigan. I oppose the civil infraction ordinance for the following reasons. As written, the ordinance appears to remove the fundamental belief that a person is innocent until proven guilty. This should never be done by a governmental agency. Number two, limited de-escalation provisions for the public to mitigate fines and fees. There must be a safeguard against malicious use by you and disgruntled neighbors. You have no execution plan, you have no budget or existing staff to manage the administration of this authority. As written, this ordinance will weaponize both general and zoning ordinances and provide every neighbor a trigger. Process. I recognize many of you from the marijuana opponents that attempted to assert its belief into our community. I am in disbelief that you are proposing this ordinance without a lengthy public input session. Why? Is it because your short-term rental survey is a failure? I've received no phone calls, no written material, no mailers, nothing. Sadly, the new day, new leadership promise you made during campaign season has not manifested itself into reality. The current administration has achieved a fracture depth in 6 months that it took my administration 6 years to achieve. Congratulations. Wow. The point is, this administration must prove its ability to provide leadership, public engagement, and transparency through communication and deliver some degree of measurable positive actions. Thank you.
Thank you, Ron.
You.
Dan Soper, 8107 Old M72. There's a lot of pros and cons on this. I understand some people's consideration. My consideration is that I'm driving through Williamsburg, a nice town of Williamsburg, and all I see is junk. And I said, why do we have all this? We have ordinance, we have, why don't they enforce them? Why do we have to look at all this stuff? We have to follow the rules. Why do they have the rules? Why do they have Deb? Why do you have anybody if the rules aren't followed? Why have board? Everybody do what they want. So I understand there's consideration on the rental and some other things. But if you'd have the civil infraction, at least she has the chance to start the thing rolling. And once it's rolling, if you have a legitimate answer, maybe it'll get thrown out. But at least the people are in violation, and definitely they have the right to do what's right. The rest of us don't have to look at it. It's a pretty big eyesore, and there's a lot of people that are really ticked off about it. And I've asked Deb, why can't you do anything? And she says, my hands are tied. We need civil infractions so we can start the process. Then they may have paid taxes, they may have everything paid like she said, but the rest of us have to look at it. Want to put it back behind your building, put fences or something. So I really think that we need that in some cases or all cases, and then it can go to the court and they can decide what's right and what's wrong. Thank you.
Thank you, Dan.
My name is Elmer J. Fudd, and I'm not going to tell you where I live, but I can give you my property number if you would like to know what it is. I don't have to tell you that.
That's not necessary. Please continue.
How many of you were born and raised in Williamsburg? Raise your hand.
This is not interactive. This is your chance to share with us your thoughts.
That's right, and I want to know how many born and raised here. I'm looking at all these people that you think I should turn against. These are good people. You're trying to pit neighbor against neighbor, uncalled for. If you read the Constitution, it says we the people. And we're the ones that hired you, and we're going to be the ones that are going to fire you from your job. And that's going to be all there is down the road. These are good people. This is a very nonsense ordinance to get neighbors mad at neighbors. Hey, maybe I don't like the color of his mailbox, so I'm going to call the township, and you're going to really go after him, or maybe he cuts his lawn at an angle, or maybe he does it in a circle. Maybe don't cut it at all. Is that really necessary? For have you pit neighbor against neighbor? Williamsburg has not been about that. I've paid taxes in Williamsburg for 47 years. And I'm going to keep paying them. I have to. But I'm not going to pit my neighbors against them or me. Thank you for your time.
All right, thank you.
Okay, my name's Neil Shalagowski, Amos Wood Drive. I don't have a prepared statement, but when we voted you people in, and unfortunately I voted for you, it became a contract between you and us, and you were to do what benefited us. But you've come into this community with a vendetta. You brought in your show of force first to show us that you've got the law enforcement behind you and on your side, and that by God, you're going to use it to the best of your ability. You know, we've got farmers, welders, construction people, and in their yards, yeah, they've got a pile of steel because they repair things with it. We got people that restore vehicles. We got, in all these, what are you looking for? Are you looking for a pristine environment? Maybe it's some agreement with the horse show people coming here. I don't know. Maybe I'm a conspiracy theorist on things like that, but the last time I spoke with you at the last meeting, I said, where's the money from these fines going? And you told me we take it. I find that troubling. I really do. That's all I've got to say.
Jim Gaskin, 8696 Church Street, Williamsburg. To help you all out, 5 minutes is right here in your notes. That's where it says it right here. It's written down. I circled it so you can see that if you'd like to. So with the 2-minute time limit, I learned tonight, I'm sorry, to you and through you, thank you for coming. Your statement was a little different than things I've heard coming out of the office. I appreciate it. You told me that there are counties that don't have an ordinance. I say put it to a vote. Don't have an ordinance. You want it? I don't. Obviously, many people don't. Some do, but let the people vote on it. Take a chance. We're not an HOA. We should have more than 3 minutes because you've taken more than 3 minutes to discuss this behind doors. Give us the opportunity. 2018, the group said, stop this. Don't talk about this. And at 2018, it stopped. Now we're here we are again. Somebody, I don't know who, brought it up again. I'd like to know who brought it up and what kind of money they're getting out of it. Somebody's getting something. Somebody's getting money. I'm worried that if somebody comes on somebody's property and they don't know who, they're trespassing. Michigan stand your ground laws make crazy people. Somebody could get hurt, and I do not want that to happen. I'm worried about that. What happens if somebody comes on my property, I don't know about it, and they get bit by my dog? What happens if somebody, how do we know who's coming has the proper ID? We don't know about the proper training. I got so many things written down here. How do we know that you're not going to be targeting people? How do we know that you're not going to look at somebody and say, I don't like what he's doing, so we're going to get him? You're not thinking of the people. The only other word that I really have to say, and I hate to say this word, is the word recall. If you can't listen to your people, then you can't be nothing but part of the people.
Okay, thank you, Jim.
James Snyder, A316 Old M72, downtown Williamsburg. And yep, I'm the guy that has all the snowmobiles and all the boats. I've never thrown a neighbor, friend, or township resident under the bus, but Mr. Soper is the one I knew, but now he said he admitted to it. I'm in violation of the outside storage. I actually went to court for a year over it for outside storage. This is where the problem is. The attorney said junk is junk. Well, junk isn't junk. My stuff is not junk to me, is not junk to my friends, is not junk to my family. We all enjoy it and have enjoyed it through the years. What somebody likes, that's their choice. And if you go look at outside storage, Mr. Soper, I've never turned anybody in. He's in violation of the same thing. And it's like, just like the board, the last time they took me to court, there was 3 members of the board that were in violation. They had to go back, fix their thing, and then go back and take me to court. And it's all documented. I'm just telling you, this is what's going on. People, it's like a neighbor issue, whatever it is. Mr. Soper moved in after the fact. I've had stuff for many years. It's mostly people that move in after the fact and want to go, you know what? I want things perfect because I have $1 million boat, $1 million truck, $1 million building. I don't like what Mr. Snyder has because he's lower beneath me, whatever it is. That's exactly what you saw tonight. That's what happens. And you have to weed through that stuff because these people are using you as their enforcement agency. And it's like, he's driven down. I see him all the time. I wave at him. I've waved at him multiple times. He's never waved at me. But if you look at my property, I've been cleaning it up. I hired a kid all summer long to clean it up. And you know I have been. So it's like I'm working with Deb Graber. She's been great. I've talked to her, worked with her. No problem there. And this kind of screwed up my whole plan what I wanted to talk about. But what's the level? Is it because one person has one big RV behind their building, one boat behind their building, or Jim has 5 boats? What's the level? You guys got to sort this out in the zoning. Thanks.
Good evening, Rachel Steelman, Chris Brode. While I once believed a civil infraction ordinance or similar policy could be beneficial, I am now opposed. During the development of our master plan, I served on the planning commission and participated in the phase where we gathered feedback from township residents. Looking back, I believe we focused too much on defining what rural character looks like and not enough on what rural character feels like. The rural character that attracted me and many others was never about preserving scenery. It was about thoughtful growth, respect for property rights, neighborly courtesy, personal freedom, and a community where government intervention was limited. Today, I'm concerned we are becoming so focused on preserving the appearance of rural character that we are losing many of the qualities that created it. My concern extends beyond the ordinance itself to the overall direction of our township. Residents have witnessed rapid zoning amendments, inconsistent handling of permit applications and resident concerns, varying treatment of ordinance amendment requests, and what many perceive as an increasingly aggressive approach to zoning enforcement. Government works best when it earns cooperation through fairness, consistency, transparency, and mutual respect, not by expanding enforcement authority. It's not too late to pause, take a step back, and ensure we are moving in a direction that truly reflects the values of this community. Taking more time is not a sign of weakness, it is a sign of thoughtful leadership. Listen to your constituents, rebuild public trust, and allow this conversation to continue before creating new enforcement authority. Most importantly, remember that protecting rural character means protecting both the look and the feel of our community. If we continue prioritizing regulation, enforcement, and rapid change, we risk creating exactly what our master plan says we want to avoid. A community that feels more urban, more bureaucratic, and less rural than the one so many of us chose to call home. Thank you for your time and consideration.
Thank you, Rachel.
Hi, my name's Jamie Gaskin, 5653 Vinton Road. I just want to reiterate, under the original article, if everybody wants to turn to Whitewater Township zoning ordinance, Article 22, it says, we can be subject to a fine of not more than $500. Every day that such a violation occurs shall constitute a separate and distinct offense under the provisions of this ordinance. I understand that we heard that that doesn't usually come into play, that that's not a concern. It's right here in writing, and that makes it a concern. The zoning is such a large, wide umbrella term. There's so many things. And it's not just a matter of, is this a nuisance? Is this ugly? Is this unacceptable? It can be something as simple as lawn decorations, lawn ornaments. Maybe we don't want anybody to have, Christmas decorations in their front lawn anymore. Anything from how high the grass can be or what colors our houses can be. Right now, we're having a very difficult time trusting you as a township board. I'm going to be very honest with you. I don't like this feeling. I don't. I want to be able to trust that you guys have our best interests, all of us, you guys included, as a community, our best interests in mind. But right now, I can't even foster trust that that we aren't going after somebody because maybe their fence is a little high or whatever. We understand that that's going to cost a lot of money to fix. So are we looking at something because it is of a health concern, or are we looking at something just because we don't like it? And that right there is the gray area, I think, and this is what we're really concerned about right now. Thank you.
Thank you.
Hi, good evening, everyone. Kelly Bowman, 5149 Vinton Road in Williamsburg. I have a lot of great neighbors, and I feel that some people are really going to struggle as this moves forward. I'm completely against this civil infraction. I feel that it disproportionately cripples the poor, triggers cycles of unimaginable debt, costs jurisdictions more to collect than they bring in, and criminalize poverty rather than deterring actual behavior that is maybe unsightly. I mean, there's something that we can do as a community if there is a property that maybe they want to clean something up, maybe they don't. But if they do and they don't have the means, could we set up a committee? Could we ask our fellow neighbors to volunteer a day to help assist instead of finding someone who probably might have food insecurities? We have a lot of that in our township. Food. People are hungry. And we're worried about what's in their front yard. So I would appreciate it if we look at being more of a community and putting together something that would help someone who otherwise doesn't have the means, doesn't have a trailer, doesn't have money to get rid of it, doesn't have physical strength. Thank you.
Thank you, Kelly.
Randy Steelman, Chris Road. Once again, I believe we're putting the cart in front of the horse. As the one lady just said, their zoning umbrella is huge. It's huger than anybody in here can even imagine. When anything not written in zoning is illegal, if we don't give you permission to do it, it's illegal. It's the most asinine thing I've ever heard. It's not how the rest of our government and law works in this country. Apparently zoning is the exact opposite and takes everyone's rights away. Therefore, I think we should just get rid of zoning entirely and maybe try something new. But it's always been working the way that we've been doing things. So You know, we need to focus on real problems. The civil infraction thing is fine. I think down the road, it's going to be fine to have some sort of civil infraction thing. But we need some really clear rules that are really simple and easy and common sense. And we don't have that right now. That's what we asked you guys to work on, was to get what we had sorted out and common sense. And this is skipping all that and going to this, and then we'll figure the rest out later. It's backwards from what we need you to do. We have real problems in this township. This is something that's, you know, coming down the pipeline here. There's, you know, this looks like it's ready, you know, we're going to do some STR thing and then we're going to attack people with it or whatever. We already have, no offense, Deb, but you know, we do have some aggressive zoning going on, whether it's her fault or she's just doing her job very well. In the past, zoning administrators, you know, didn't just follow up on every complaint. Yeah, I got a neighbor that just doesn't like his neighbors. That's common and normal, and it happens. When somebody's really doing something that's affecting the neighborhood, you'll get lots and lots of complaints about it. And it's, you know, this is something we have to handle. And we need to be able to have some way to pick and choose rather than, nope, this is the rule. And, you know, anybody violating it, we're going to be after you and all that. It's like, is it hurting anybody's health or safety or wellness? It's too much. Thanks, guys.
Okay, thanks, Randy.
Brenda Baker, 5982 Cook Road. I'd like to thank you for coming. It was very informative, but I feel like it really sounded like Traverse City. And we moved to Williamsburg from Traverse City. We don't want HOAs. So I'll start with that. And then I'm really confused, I guess, at why we are here again. It feels like the same meeting. It likely is going to be the same outcome, just a different location, more money spent and time wasted. Hopefully after this third meeting, you guys will listen to the Whitewater Township residents that we do not want this. And honestly, I'm not sure why we're talking about civil infractions when a decision about a short-term rental ordinance is still up in the air. We all know that, well, in my opinion, the civil infraction discussion is directly related to the short-term rentals. And I agree, it's putting the cart in front of the horse. Listen to the residents about allowing short-term rentals and define what ordinance is first. What's allowed, what's not allowed. That's where your energy should be spent. Then determine how to police and enforce it. I really wish that you would be transparent on the amount of complaints and the addresses that are complained about. Because the buzz is that we won't have enough manpower to police the offenders of the to be determined ordinance, but I think it's just overblown and exaggerated. Maybe we should FOIA the complaints made and the addresses made on. I'm not talking about one person making complaints on all short-term rentals, even though they don't live next to or near one. I'm talking about real complaints. I just highly doubt that there would be an issue enforcing a few bad apples. Again, we moved out of Traverse City to be left alone by the HOAs and have more property rights. This overreach of civil infraction gives the township the power is not what I signed up for, and I think it's also hypocritical. Thank you, Brenda. Thank you.
All right, who would like to come forward next?
Kim Angus, Brown Bear Lane. For those of you that don't know me, I spent 15 years on our planning commission. Don't hold it against me. A good number of those I was the chair. Our zoning ordinance is not prepared for this. Our general ordinances are not prepared for this. Even if you have listened to everyone here and you still think this is a good idea, you need to get your hearing checked. But additionally, our ordinances are not in order. Get your house in order before you try to enforce something like this. You don't have things on the books unless you're willing to enforce every case, every time. Do you know that you're not allowed to have a boat parked in your front yard according to our ordinance? You're not allowed to have a snowmobile or a trailer parked in your front yard according to our ordinance. It is illegal to have a yard light that is not on a motion detector or is an LED as opposed to sodium. We have ridiculous ordinances. Most people don't know they're in there. Brandy, I'm sure you came across a lot of them when you were going through our ordinance. You fix the ordinance first. Then you maybe consider upping the ante on your enforcement. I do want to ask the attorney a question, and it'll be up to you whether or not you answer it. But we have 50 years of zoning. We have 50 years of renting the family cottage. We have 50 years, and in 50 years, this township has never once prosecuted someone for renting said cottage. If you've had a use for 50 years that has never been prosecuted, can you really go after someone? Because it's not on the books. And that is our person who you've never seen in your practice who did spend a day in jail for this, because it's not on the books.
All right, thank you, Kim.
I'll be a little more direct and maybe a little less nice. We don't trust you, period.
All right, who else would like to come up and make a public comment?
Y'all know me, but I'm Barb Dean, residence, the barn's at 10751. I have three residences at 8778 Carnes Road, 9010 Carnes Road, at 9002, plus the farm. To begin with, I don't plan to go through every concern I have about this proposal. I'll attempt to summarize my overall view. It's my belief that this township has primarily been an agricultural community from its beginning, considering the Civil War, Grandpa and my husband's family. The farmers I know and the stories I've heard about our ancestors have led me to believe it has been a community of residents, helping residents in times of hardship, sickness, fires, accidents, and deaths. I have heard at several Whitewater Township meetings, folks moved here because of our rural nature and our community. So this civil infraction, to me, is designed to pit neighbor against neighbor and create mistrust. Just a couple examples. In the process section, beginning with field investigation, okay, without notifying the landlord, there is a problem or there is even a complaint. That's the order. I read it down. In fact, the language reads, Whitewater Township employees should verify from a public right-of-way if possible, and should take whatever precautions are necessary to remain safe. Really? Sneak around our properties? Don't even tell us? That's horrifying. How about notifying the landowner first? That doesn't happen until a few steps later. Then surprise, here's the complaint and many fines. Very punitive, but the lawyer will make money from this, I'm sure, because they help write it. Question? Finally, the most offensive language for me in this whole thing is allowing anonymous complaints. Oh my gosh, that just isn't fair. You cannot sign your name. You should not be allowed to complain against anyone. I'm upset and I'm sickened by the tenor of this language and intent to be punitive to many Whitewater townships. When will it come time for us to realize individually different, and that's what brings richness to our community? Let's start working together instead against each other's.
Thanks, Barb.
Mike Jacobson, the Skeegamock Point Road. This 2-minute thing is ridiculous. You've given us 3 minutes at a minimum on all these other times when there's a big crowd, and now you even curtail that. All the time, you restrict our right for free speech. Overwhelmingly, the citizens are against the civil infraction ordinance. To my knowledge, there's no evidence to the contrary. If there is, you haven't produced it. That being said, you haven't dropped the issue like you should. Instead, you changed lawyers so you could get the opinion you wanted. Everyone in this room knows lawyers are an agent of the court and don't care if their advice is unconstitutional because they get paid whether their advice lands us in court or not. That means they get paid win, lose, or draw. The board didn't follow its own rules, Robert's rules, its own bylaws, or the Michigan Opens Meeting Act by having this meeting in a whole different county than ours or our township. I think the community should be allowed to ask the lawyer questions because the community is the one who is under the gun here. I would like to ask the lawyer to explain again to the board why you can't pass anything unless you have our support. Also, if the township is not going out and finding violations, they're letting people accuse their neighbor of it. Isn't that an accusation? And aren't people who are being accused have the right to know who their accuser is? I'd like him to answer that question. The stuff in my yard is my stuff. It's what it took for me to make a living here and pay my bills and pay my taxes and keep my family fed. These people who move to our community because they want the country life and then get here and can't assimilate to the country lifestyle are naturally gonna pick on the people who are here first because for whatever reason, they think they're better than us. That's wrong. And I got a lot of other stuff to say, but you people won't allow the public to voice their opinion. That you are curtailing our right to free speech. Your job is to listen to us. You work for us. We don't work for you. We're not your subjects. You are our employees.
Okay, thank you, Mike.
Jade Jacobson, Indian Road, Keewaydin. I do not live in Whitewater Township at this current time, but I was born and raised there. I also will be inheriting 2 separate properties, so I have a vested interest not only in the township, but this issue. Thank you. I would like to know where you derived your legislative authority from. When I read the state constitution, it says in Article 4, Section 1, quote, except to the extent limited or abrogated by by Article 4, Section 6, or Article 5, Section 2, the legislative power of the state of Michigan is vested in the Senate and the House of Representatives, unquote. Nowhere does it say that this board or anybody on this township has that authority. Also, in Attorney General Jennifer Granholm's opinion, MC 7096, it implies that if the government doesn't own it, they can't zone it. When I looked it up, Whitewater Township is a general law township, quote, which is the default baseline form of civil township government used primarily in states like Michigan. Unlike a charter township or incorporated city, it operates directly under standard state statutes with a decentralized board structure, providing fundamental local services. I then had to look up the meaning of decentralized board structure. The definition I found states that it spreads governance, discerning making, and advisory responsibility across multiple committees, regional branches, and autonomous units, rather than concentrating them in a single top-level board. This is not how Whitewater Township operates. So once again, I ask you, where does your authority to legislate come from? Then I looked up the civil township government. That definition says it is a fundamental unit of local government in the United States established to manage the affairs of a specific geographical subdivision of a county. A civil township provides a range of essential administrative and municipal services to its residents, especially rural or unincorporated areas that do not have their own city or village government. No mention of the ability to zone is mentioned. Once again, Whitewater Township doesn't operate like this, and once again, sorry. So finally, I again respectfully ask you, where do you derive your legislative authority from? And the last thing I would like to say is if you don't like how things look in Whitewater Township, then maybe you should be the ones to move out.
Okay, who else would like to step forward and make a public comment?
I'm Mark Williams, Williamsburg, and I had a whole bunch of stuff wrote down here. I was gonna go through how it's the people that made Whitewater Township a great place to live and how the heritage came to be. And most of the people already said that. Mike quoted some stuff from here. I don't know how he got it off my page, but he did. And so did the two Rons. So all I can say to them is ditto. But I wanted to address the word junk, and Jim used it. And I have some junk, and my dad didn't like it. And this was probably close to 20 years ago, and my dad would come up and he was irate at all of this junk around. But what was really happening is at that time, I had a teenage son, and he had 6 or 7 buddies. And we had a nice shop, tools, welding equipment, and everything. So they gathered at our house. And I said, Dad, you're not looking at this right. He'd say, yeah, but look at that one. It hasn't run in a month, and that one's broke, and that one doesn't have any wheels on it. And that was all true. But I said, Dad, you're not looking at it right. Right here, every night, I've got 6, 7, 8 teenage boys. I know where they are. I know what they're doing. And yeah, that car didn't run in a month because altogether they could only get enough money for gas for one afternoon. Then they're broke for a month. Teenage boys don't get in trouble if they don't have any money. So let them keep going. Now, they learned enormous amount of not just repairing, but creativity. I've got a golf cart out there with a 3-cylinder snowmobile motor in it that they built. I've got a lawnmower with snowmobile tracks on the back. And they fabricated all that. They learned a lot of stuff. And now those boys are engineers, fabricators, professional people. And I looked at it as it was like school. They learned stuff every night on their own. And if you know kids, one kid can learn from another kid way faster than the teacher can put it in. Now, as far as junk goes, if anybody would be interested in a set of exhaust manifolds for 19, no, serious, how about 1938 Duesenberg exhaust manifolds? Is that junk? Or how about a pair of wood spoke Packard wheels? Is that junk? You know, it's,
Thank you, Mark.
okay, thank you.
Howdy, guys. Dave Williams, 11552 Watson Road. I built that lawnmower with the tracks. It's got skis. It's got bigger pulleys, so it goes faster in the snow. It's pretty sweet. I didn't know he was gonna say all that stuff, but it's all true. Me and many of my buddies, we learned all kinds of things. I'm a certified welder, certified auto mechanic. We built buildings, commercial buildings, we built homes, we built garages. I currently run a gravel pit. I have junk there. I yell at it every day. It makes us piles of money that we spend right back on it. We put parts right back into the equipment. I run that business because of what I learned dealing with all my junk. My friends are engineers. My friends have been all around the world. We built incredible things. I don't do drugs. I don't drink. I have some junk, I guess, if that's the way you look at it, which brings some other people have said these things. There's major problems with this whole ordinance. One, it's nonsense. Definitions. Where are the definitions? It's full of vagueness. It's all vague, which is what lawyers love because they can navigate their way through it. What is an eyesore? That's a current model Silverado. If you haven't seen them, they are hideous. Toyota Prius, they're pretty ugly. That new Cybertruck thing, that's pretty ugly. You know, 65 CJ5 or a Willys flat fender, that's not very ugly. That's a pretty sweet looking rig. It's all, there's no definitions. What is blight? Blight by definition is something that degrades something else. Something that was good has now been hurt or damaged. We've heard from people all here. We've had something good in this township for longer than I've been alive. That goodness that this whole community thrives on, you guys are the blight. You're ruining the good thing that we've had. Assimilation, that's what you guys have to do when you move into our township. You find the goodness in us. Live it, breathe it, honor it. More triggers have been pulled in this township than you guys have had breaths. More cars have been built and parted out and rebuilt and parted out and rebuilt than you guys have had meals. This is normal stuff for our community, and it has been for a very long time. There's a cemetery on Vinton Road. There's a cemetery on Front Street. Go look at all those names and talk to the people that have built this town and tell them that what we have and what they've created,
Thank you, Mark.
tell them that they're junk. I'm Dave.
I'm sorry, Dave, your time.
Thank you for your time.
Is up.
Rodney Dangerfield would say tough crowd, real tough crowd tonight. My name is John Boucher. I live in Clearwater Township, but I have property in Whitewater Township. And I came here to talk about the rules for the upcoming short-term rental stuff. And now I got swamped by all you guys. Thanks a lot. But anyway, my experience with the STRs are that these people right here, I'm talking to you, get ambushed by the people who make money on the STRs. And the people who don't come talk to you are the ones who don't yet realize that when their neighbor dies and the kids can't afford his house because it's on Skegamog Lake, they're going to have a VRBO come in, tear it down, put up a 9,000-foot square house, 12 bedrooms on a 70-foot wide lot. And my Shangri-La goes to hell. So when you do make these rules about STRs, I'd like you to consider the quiet voice of the person who worked for 50 years and paid taxes for 50 years to get his butt on a nice piece of property, a farmland, a lake, a view property, and have somebody from an STR who lives in Connecticut who owns it, or in Argentina. I've stayed in VRBOs and Airbnbs in Florida, and I had to call the owner in England to find out how to turn on the well motor because it blew a fuse. I had to call somebody in South America the next time I went down there. These aren't our neighbors always. Sometimes they are. I do have a neighbor on the end of my block related to somebody right there that does an amazingly good job of running an STR because they live next to it. They're great people, and so are the people they rent to. But you can't promise that. So I'm here telling you about my fears of what will happen with lots of STRs. And that's all I have to say. Thank you.
Thank you, John. We're going to take a 5-minute break here. So people have a minute to get a drink or go to the restroom. We'll reconvene at, I'm sorry, I meant to say 5. I'm looking at the clock. 8:05. We'll restart. Hey, we have the podium open for another public comment.
Julie Zenas, Skiggamuck Point Road. Good evening. I'm here to express my support for adopting the civil infraction ordinance. The purpose of the ordinance is straightforward. It provides the township with a fair, consistent, and efficient way and neighbors to enforce the ordinances that are already in place. Rules will only work if there's a practical way to enforce them. I've heard repeated claims that civil infractions take away property rights. They don't. Property rights have always existed alongside reasonable laws and local ordinances that protect the health, the safety, and the welfare of the entire community. This ordinance simply provides the civil enforcement process when those existing rules are ignored. I also want to recognize our zoning administrator. She is experienced, she's professional, she works with diligence, she works with compassion, I've seen it, to resolve complaints through education, communication, and voluntary compliance whenever possible. A civil infraction ordinance doesn't replace that approach. It simply provides another tool when repeated violators cannot be resolved voluntarily. It promotes fairness by ensuring the same rules apply to everyone. Finally, I'd like to make and share a personal observation. I attended the September 30th, 2025 meeting, COI public meeting. I left feeling unsafe because I expressed a viewpoint that was different from some of those who spoke. The aggressive tones, the yelling, the aggressiveness to the board, whether you like them or not. Public meetings should be a place where residents can respectfully share differing opinions without being intimidating. I also know there are residents here, and there are residents that were there on September 30th that are not going to speak because they fear the reaction they might receive. Community opinion should not be measured solely by who is speaking at a public meeting. I respectfully ask the board to evaluate the ordinance based on its merit, the need for fair enforcement, and the best intentions and interest of the entire township, not simply who speaks the loudest in these meetings. Thank you.
Thank you, Julie. Connie Highmore, Beggs Road. I'm going to veer off with my 2 minutes and speak about another difficult subject. My public comment pertains to the alleged embezzlement case against Clerk Hoeksema. For those not aware, in April, 4 board members alleged that the clerk paid herself just under $3,000 in unapproved hourly wages. Please understand that all members of the board were aware of the wages. The trustees watched the money, the treasurer signed the checks, the board voted to approve the paychecks. When the clerk defended her actions, the board voted to send the case to the Michigan State Police. It appears that the board, someone on the board, contacted local TV stations, newspapers, and social media pages to furtherly publicly humiliate and slander Clerk Hoeksema. Several members of the community jumped on the bandwagon and spoke in public comments at the board meeting, slandering the clerk. When I looked at the info provided concerning the clerk's pay, I assumed at worst it was a process error and could be handled at the table. But no, since there's been no transparency in the case, I submitted a FOIA for any decision made for communication between board members and the cost of the case to the taxpayers. My FOIA revealed that on June 18th, 12 days ago, the prosecuting attorney responded to the Michigan State Police that criminal charges are declined. The investigation did not establish probable cause that the clerk committed a prosecutable criminal offense. There's no case. And I will repeat, all charges against the clerk are declined. What I find disturbing is that the board has had this info for 12 days. They had a board meeting on June 25th, 5 days ago. No one spoke about the subject. This is disturbing that I can't finish my comment. Thank you, Connie. I want to tell you that Clerk Hoeksema, I'm going to finish with this. I'm proud of you. You held your head high. You handled yourself in a professional manner during this slanderous case against you. You never wavered in your innocence. You put on the armor of God and you trusted you would be vindicated, and you were. So stand tall. I congratulate you on your victory, and I support you. All right, who else would like to make a public comment?
Mark Bach, 4211 Broomhead. I've been to a few of these meetings. I don't go to all of them, but when things get hot, I tend to show up. The ordinance hasn't even been passed yet. We're just discussing it. And as the people that are still left here will agree with, is we're already pitting neighbor against neighbor. And they have to come and defend themselves up here, which is sad. If and when this gets put through, it's only, in my opinion, going to get worse. And we've already heard that this year or this evening. It's clear to me that the majority of the people here are not in favor of it. And we just heard that people are scared to, or maybe scared to get up and speak. Well, that's part of living in this country. If you don't like it, get up and speak. You might be saying, well, Mark, you didn't grow up next to, or you're not living next to somebody who's got junk in your yard. Well, I've had somebody with junk in their yard bad for almost 30 years, and I didn't like it. But there's my business, his business, and God's business. And the bottom line is, I never said a thing to him or to this township, and I didn't like it. But all I did was lead by example. And I tried to make my yard look nice. Not that it's the best, but I tried to mow things out, keep things cut. Well, unfortunately, he passed away. And the new neighbors is here. And he's cutting his grass. He's removed a ton of belongings. And it really has been cleaned up and it feels good. For the people that don't want to wait the 20 or 30 years, consider a gated community. Thank you.
Beth Williams. I live on Watson Road. And actually, I came here thinking of the meeting being more about what's considered, what violations are violations. What are we really talking about for violations? Turns out it's about whether it should be, which form of ordinances you should be prosecuting or not. So maybe what we really need to focus on is have something about what are those ordinances that we want to enforce, not which way we want to enforce them, but what are those ordinances? I mean, if I have a car in my yard for a month without being used, is that on there saying that that's a violation? I don't know if it is or not. I don't even know. I suppose there's someplace I can access it. I don't even know where I can access this to find out what those quote violations are. And I think that's a lot of what our talk is about, is we don't like certain things being called violations. We don't like certain things being called no-nos that we shouldn't do. So I guess we really need to figure out what is on that list of things that we could be charged with, and go to that point and say, okay, we need to change that ordinance. That shouldn't be on there anymore. Or maybe something else should be on there. Thank you.
Tom Slopsma, 9693 Miami Beach Road. And I had to prune all my stuff down to get to 2 minutes. I probably didn't make it. So my comments regard the three ordinance agenda items I see. Number one, I see no changes to the junk ordinance fines since 2005. So I think that's good. I do agree with increasing the parking ordinance fine to cover increased costs of towing a vehicle. And then number three, regarding the zoning, my understanding is our current zoning enforcement is misdemeanor prosecution, placing high attorney costs on defendants. It has potential for jail time, and a guilty verdict results in a criminal record, which can hurt their future employment and often drives increased insurance costs. Changing to civil infraction citation allows the defendant to choose an informal hearing, avoid the high defense attorney costs. There's no threat of jail time, no threat of criminal record, so the civil infraction is much lower cost for the defendant. More defendant friendly than our current process and matches our other ordinance maximum fines. The board's proposal gives the defendant multiple in-person contacts from the zoning administrator, plus multiple letters, written violation reports, and directing many attempts to resolve concerns before a ticket might be issued and before a court hearing. Changing to the civil infraction enforcement appears more defendant-friendly, gets us consistent with the surrounding townships, plus the city of Traverse City, and about 90%, more than 90%, I think, of the townships in the state. Now, I listened to a lot of comments here by other folks. And my initial reaction is, because I think going civil is much more defendant friendly. My reaction to a lot of the comments are, boy, you folks, if you don't like the ordinances in the township, work with the PCN board to get ordinances that you think are fair. There's folks who worked on the PC here for 15 or 20 years. And wow, all the ordinances are bad.
Time up on this. I'm not sure if you heard the dinger, but
Thank you.
okay. All right, who else would like to make a public comment?
I'm Randy Davy. I live at 9034 Whitney Road. In regards to your junk ordinance, you need to specify what junk actually is, and you also need to remember that one man's junk is another man's treasure. And there are private property rights in this country. There are also many Supreme Court cases from the 1860s that have never been overturned and never been challenged that do not give you the rights you have. Most of the US code statutes is based on US banking law and securities. It's not actual law. Okay. If you doubt me, there are many judges and many cops that'll tell you I'm not the person to mess with. Okay. I'm also not very good at public speaking. What you need to understand is that you, when it comes to code enforcement, have the same responsibilities as a police officer. Without a warrant, you cannot walk on somebody's property and walk around it. You can walk up, knock on the door, and leave. That is it. That's why he's telling you to observe from the road. There's a lot of things that he didn't take into consideration when he gave you advice. You might want to research it. Because if you come for me, you ain't gonna like the outcome.
All right, does, Mike, I think you spoke once already, is that correct?
So there's two public comments, but I can't use them both?
We have public comment after later again. Yes, we do, but you can't use two now. We're in the first one right now. Who else would like to make a public comment tonight? This is your last call. All right, then we will proceed on our agenda. All right, so next we move on to new business. So the first business item to discuss is consideration of the zoning ordinance enforcement language. So one thing I want to clarify, just first of all, is the current zoning ordinance penalty language indicates criminal misdemeanor. And I think some of the people spoke about, there was a person here that's involved with the township, criminal misdemeanor, potential jail time. And so what we're talking about is changing that to civil infraction. So it's a civil process. So in order to discuss further, and there might be some questions the board wants to ask of the attorney based on citizen feedback, I need a motion on the floor.
I'll go ahead and make that motion so we can discuss this. I'd like to make a motion to direct the planning commission to review and amend zoning ordinance Article 22, violations per attorney recommendation, conduct public hearing and provide recommendations to the township board as presented.
I'll second.
So motion made and seconded. So now discussion. Randy, you're first since you made the motion.
I will go ahead and start with this. I personally believe that a civil infraction mechanism is the best way to enforce our zoning ordinance. I think it's important for us to distinguish between what is the enforcement mechanism and what the ordinance requires, not only in terms of zoning, but in the other issues we're going to talk about this. The Planning Commission and the Township Board.
Excuse. We forgot to vote on your motion, so I apologize for missing that.
Well, we're in
So,
discussion.
Yeah, correct. Oh,
We have
I'm
discussion,
sorry.
yeah.
That is correct.
Yeah.
All right.
Just need
So
a
we're
second.
fine. So we had a
Yeah.
motion and a second. I'm sorry, Randy, can
That's all
you
right.
start over?
Sure. Well, I believe that the civil infraction mechanism is the best way to enforce our zoning ordinance. The Planning Commission and the Township Board have spent considerable time and money improving and clarifying zoning requirements. We've cleared up many longstanding issues and are working hard to make procedures and requirements reasonable and clear. One of my past takeaways from our meetings is that people want a clear enforcement policy, and I think that's what's being offered here. And I'll tell you, I have to go back to comments that have been made before about I'm going to confine my comments to the zoning ordinance. I heard a person, Kim Mangus, speak to 15 years on the Planning Commission and talking about how the ordinances were problematic. I heard her at a public meeting so about a month or so ago, say that they couldn't locate how property was zoned. They couldn't find sections of the ordinance. Yet, at the same time, there was effort to review site plans, approve rezonings, approve special uses without the benefit of knowing what the ordinance is. To me, that's the biggest insult to property values that you can possibly imagine. A lot of work has gone into making the zoning ordinance readable, clear, and understandable by residents. I don't personally favor any effort, as was done in the past, to have an ordinance that is unclear and unidentifiable. It's not my words, it was the words of the former chair saying that. It's a problem. I believe that the Planning Commission and the Township Board have made major steps in terms of clarifying it. And again, I think we need to distinguish between the enforcement mechanism and what the ordinance requires. The ordinance is in 100% better shape than it was a few years ago, but there's more work to do. In fact, there's even a meeting tomorrow night with the Planning Commission to work through additional items. We've gone through quite a few meetings, working meetings, very long, tedious meetings, talking about various provisions. We've enlisted the help of a professional planning consultant who has helped us walk through the language, point out areas that are not as clear and problematic that we need to address. We've clarified it. We're making progress towards having a zoning ordinance that people understand, that have a clear and predictable process, and that the township can benefit from. I want to see our township grow properly. We have a new master plan, And that effort was substantial. Some of you participated in that. A large part of the zoning changes that are being made now are being driven by what the master plan calls for. And I've got some other comments later, but I'm going to save them for more discussion on this.
Okay, Tim?
I'll be supporting the policy change for the following reasons. Nearly every zone community has some sort of enforcement policy. In this township, the only option available if voluntary compliance is not achieved is to hire attorneys, charge our residents with a misdemeanor, and go through the long legal process. We have a current case initiated by the prior board, and now a jury trial is set for September. Nearly 2 years later, at a cost of tens of thousands of dollars so far. The only other options would be to not enforce the rules and regulations of the township if a citizen refuses to comply or become an unzoned community. Citizens that have complained in the past have sometimes felt unheard and ignored. If not enforcing our rules and regulations is the option we agree to, I think it would be a great disservice to the dozens of past board members and commissioners that helped create our rules and regulations over the past several decades. Why would any former board member or commissioner suggest non-enforcement of the very rules and regulations they helped to create? Also, I believe the majority of residents in this township expect its board to enforce its rules and regulations to protect their investments in this community, along with their health, safety, and welfare.
Right. Wendy or Jill, any preference? Who would like to go next?
I don't feel like I can support this for the following reasons. One, this is our third meeting that we've had with the public, and I just hear the same thing over and over again, that the vast majority of people are not ready for this. I've said it from day one that I feel like we're doing this in the wrong order. We've talked about the ordinances not being clear. We have some big projects that we're in the middle of working on that will define some of these things going forward. And I think, again, we're putting the cart before the horse. I think we need to make our ordinances very clear and very defined of what you can and cannot do before we try to start enforcing them. And I do think a lot of good work is being done in that direction. I just don't think that we're there yet. Right now, I guess my feelings on the criminal versus civil infractions is the protection to the residents right now is the fact that we do have a criminal infraction because we can't afford to sue everybody that we try to enforce things on. So therefore, we're not able to enforce on the few problem properties in this community. I don't think it is widespread right now that it's such an issue. It's ruining our community when we have just several properties that are really kind of causing all the problems. I think that the board needs to earn the public trust. I've just heard a lot over and over, not just at this meeting, but at other meetings too, that they don't trust us at this point. The big elephant in the room is obvious SDR stuff going on. I just think that we have a lot of work to do before we start trying to enforce things that we can't even define.
Okay, Wendy?
I think because I did not see the lawyer's presentation, I think I'm going to reserve a right to talk right now.
Okay.
I didn't hear what she said.
I'm not speaking out about anything at this time. I did not hear the lawyer.
Okay.
Okay. I have a few initial comments. Just, studying this in preparation for this meeting, our township has been zoned for 53 years. These are things that were reviewed in public hearings over the years, and some of you that are in the room participated in that. Back in 1994, so about just over 30 years ago, the state of Michigan allowed civil infraction as a more practical solution And the vast majority of all townships have adopted that. And particularly in our area, and there was a public comment that stated this, and this is accurate, everybody in northern Michigan is using civil infraction. The standard fine is not to exceed $500, which is exactly what we're proposing to be integrated. It parrots the MCL, so that's not any kind of a change. As I work through this, you know, tickets are kind of the last step on the bus. The goal is always to resolve things by educating people and addressing the concern. The goal is not to burn up the ticket book and be in the courthouse once a week. That's not the goal. And so it is a standard approach. This came up in other meetings. I did want to address one public comment that came from Mr. Shelagowski that he said, and he is correct on this, that at the last meeting in September, we talked about that we take the money for the tickets. That was when we were going to use a more expansive process and deal with tickets at the township. And after further review, that really didn't make sense. That's just very encumbering. And that it's better to just allow you to go straight to the district court and let an objective person look at the evidence that the township has and look at what the citizen provides and make that decision. And it's not done by the board, not done by the zoning administrator. It's done by the court in an objective way. And I think that's a really positive thing. I'd also like to address some of the concerns that people mentioned about targeting. If our zoning administrator is singling out and targeting citizens, that's an employee issue. That's not a township procedural issue. That's an issue that the board has to deal with an employee on. And certainly I would never support anything where individuals or groups of individuals are targeted. But right now, is it really fair that we have gotten involved in the past of the township and currently are involved in litigation against specific people? And ask yourself, is it fair that they're going through the process, but people with similar situations, you know, right now, it's too costly for us to do it on a misdemeanor and it takes forever. It's really not reasonable. And I think that most of the time, our zoning administrator is able to work things out by just educating people, showing them what the requirements. The last thing I'd like to say about zoning ordinance is there were some questions brought up by people about, you know, what exactly are the rules? And it's important to understand zoning is about land use. That's not where we deal with junk concerns. That's different. So most of the things that the zoning administrator deals with that I'm aware of, erecting buildings without a land use permit. And that can be a really difficult thing because all of a sudden you might put that structure on somebody else's property. And if you don't think it happens, you're wrong. It does happen. Sometimes it's in the setback, which infringes upon your neighbor, and that's not supposed to be that way. Other things that I can think of that have popped up related to zoning violations, fences too high. And sometimes they're a lot too high, not just a little bit too high. And I'm trying to think of some other immediate examples, but most of the things that I've seen the zoning administrator deal with are very clear cut and very well defined. You either did or you did not get a land use permit. And then you have to have the land use permit to get your construction permit. So some of these people have a problem with the county also because they have erected a building without paying for the permits and the inspections and getting occupancy. So I just think that people need to be aware some of the stuff is quite clear cut. It's not vague. And if there is stuff that's vague, I agree, we should fix it. And if people think certain requirements in the zoning ordinance are inappropriate, you should work with the planning commission to have those stricken. And I'm very open to that.
If I could add to that too, I want to say that for the last three years or so, there's been a substantial effort on the planning commission to walk through the zoning ordinance. And there are problems in there. They are being addressed. They are being addressed systematically and according to the priorities that the planning commission set. But I would also welcome anybody here who wants to look at those requirements and say, hey, this doesn't make any sense. Why are we doing this? Explain this. they will be more than happy to do that. And there's public comment at the beginning and at the end of every planning commission meeting. And there are people that take advantage of that. And so you should as well. And I would ask you to help the planning commission, help the township in general, come up with better ordinances. The civil infraction discussion is only about the enforcement mechanism. It's not about the content of the regulations. If the regulations need to be fixed, there's a group of planning commission members and a group of board members here that are anxious to see how that can happen. There is nothing in the ordinances that say what your mailbox can be painted, what color can be painted. There are lots of other examples that were thrown out here that there's no basis for that. There's nothing. I don't know where those rumors got started, but they're not helpful and they infuriate people. I'd be upset too if somebody told me what color my mailbox had to be. It doesn't happen that way. This is a fairly rural township with very basic regulations in place. And we're continually trying to improve that.
I have a question. Maybe this is more for the attorney, but this has been brought up to me before and I don't know the answer. So I'm truly wanting to understand this. In a permissive ordinance, if it doesn't say it isn't allowed, if it doesn't say that it's allowed, it's therefore not allowed. And so the example, again, the elephant in the room is on the issue of short-term rental. So it doesn't say that we can short-term rental, so therefore we can't short-term rental or rent. So does it say that we can midterm or long-term rent? Is that anywhere in our ordinance or, because we're allowed to do that, but we can't as residents.
This is a short-term rental.
I know it's not, but this is just
it's
an
fine to
example I'm
ask
trying
the
to
question.
clarify because we're talking about
Okay,
our
I think
ordinances being
We understand your
clear.
question.
Yeah.
Let's let the attorney answer the question.
Yeah, the rules for 30-day or longer, month to month or year to year, long-term rentals, that's not the same rules for short-term rentals. Those are rules involve landlord-tenant laws. That's a completely different type of animal. Short-term rental is a different, shorter use of the property. And therefore different rules and different statutes apply. I haven't been asked to go through zoning ordinance to see whether or not there's language in there that addresses short-term rentals or not. A case where they did that, where people thought that they had a right for years to have short-term rentals was in Garfield Township. And the zoning administrator then discovered language in the zoning ordinance that actually had specifically prohibited it. It was challenged in court and the township won. So in Garfield Township, they don't need a licensing ordinance. Short-term rentals are forbidden and that's already been handled by the court. And then there's other ways of handling it if you wish to have them. I suggest looking at Elmwood Charter Township or East Bay Charter Township. And you'll see a mix of rules there. Zoning, if you're going to have them, where should we have them? Police power, licensing, how many should we have? If we have too many, can we shrink them using a licensing ordinance? So those will be part of your discussions as you move forward.
Just two more comments. So
Sure.
the point that I was trying to make is that there's three things: short-term rental, midterm rental, long-term rental. None of them are in our zoning, but we're defining which ones can and can't be enforced. So that's just the point I was going with that.
Yeah.
And then I guess my other question is, what alternatives to a permissive ordinance are there? And is that something that we should look at where there are more clearly defined paths forward?
Well, you can always amend your zoning ordinance, okay? And you can make uses that are not permissive again. As if there was no zoning ordinance to begin with. So yes, you're allowed to go ahead and do that. But short-term rentals have been, as the case law is going forward, is treated more as a commercial use rather than a residential use. So under your zoning, whether someone is a long-term renter because they have a family or they're renting an apartment or they're renting a home, to live there as opposed to a golf weekend, or a week with your family at a vacation rental, the use may not be considered residential under some of the cases there. But you as a township have the authority, both under your general, under your rules for the statutes that are applicable to general law townships, as well as for charter townships, as well as under the Zoning Enabling Act, to make changes, to make things work for your community the way you desire to have them work. So. No, you can have a long-term rental because the landlord tenant laws apply to that. No, it's a residential use though. See, that's the difference. And you have zoning districts that allow for residential uses, period.
Thank you.
Okay, other comments, Tim? Wendy? Any more comments or any comments at this point in time? I have one more question for the attorney, and this was raised by a public comment. So relative, the example that the citizen gave was, seasonal, maybe weekly rentals, something like that, done in the township over the years. And I think we all understand that short-term rentals in the past kind of were different 50 years ago than they are now with the advent of the online tools that allow people to achieve higher levels of bookings. So how does that work with our zoning ordinance when maybe a person's been engaged in that for years? And we now have the ruling from Judge Stepka that short-term rentals are not permitted in Whitewater Township.
Okay.
Per our zoning ordinance. That's been.
Well, that's the
issued.
rest of the information, so I'm glad you told me
Yeah.
that, because I wasn't,
Okay.
I'm not involved in your case that
Current
started
case,
a couple,
yes.
a couple of years ago, so you already.
He spoke, he didn't rule on the case yet.
Right,
He
but
didn't make.
he signed.
He said that.
He signed an.
But he made
order.
it, okay.
Yes.
He
But
said
ultimately,
any-
you're right, it
He
has.
said any reasonable person could read our ordinance and say that short-term rentals were not allowed. End
Okay.
quote.
All right, but it's not
Okay.
part of an order yet. Okay, that's fine.
It says it's strictly prohibited in this township. Short-term renting is strictly
It's an
prohibited.
order.
Yeah.
Oh,
Yeah.
okay. Well, then
Okay.
it's been ruled upon.
Okay, yes,
All right.
we have it. So go ahead, Peter. If you can.
In Garfield Township, there are probably a couple of vacation rentals, I think, that exist because they existed prior to the enactment of the zoning ordinance. That's where the grandfathering can come in. If you can provide evidence, right, that you had a short-term rental before the zoning ordinance came into play, then you would be grandfathered in. You'd still, though, if you have a licensing ordinance, may end up not having a short-term rental depending on how the licensing ordinance is read. And that's a longer, or written rather, and that's a longer, conversation to have. But a way to, if you want to see an example of how that's done, you can look at the Elmwood Charter Township ordinances online, on how a licensing ordinance is done. I can do a, separate presentation on that as well. So,
Okay.
all right.
One other comment I'd just like to make for the benefit of the public is, a couple of people said, hey, I think this action is just tied to STR. And I would like to say, at least from my perspective, do we get complaints about STRs right now? It's kind of a hot topic. Yes. But our zoning administrator is very busy with other things related to activity taking place without following many of the basics of the zoning ordinance. Here's an example. Running a home-based business on a pretty large scale without ever declaring that to the township, and that is required to come to the Planning Commission for review. You're also required to notify the neighbors. That's all part of the process of living in a zone community. And so, believe me, there's lots of unpermitted structures and the other stuff that I mentioned. I don't need to repeat it, but people need to understand that that's part of living in a zone community, and these rules have been in place and built up through the years. These are not new rules, and many of them are very black and white. You either did or you did not get a land use permit. You either did or you did not put a building in the setback. You did or didn't get a special use permit. That's the stuff that's straightforward that Deb tries to address immediately, because it's not gray, it's black and white, and it's not about ornamentation on your lawn. We have no rules on that. All right, are we ready for a vote?
I would just add, and most people follow the regulations. Most people get permits. Most people go and see what the requirements are. A handful of people do not. There needs to be an enforcement mechanism to deal with that. And it needs to be efficient and clear.
Okay, so I'm going to restate this motion as was read, so everybody's clear on what you're voting on. The motion is to direct the Planning Commission to review and amend the zoning ordinance, Article 22, which is the violations section, per the attorney recommendation, conduct the public hearing, and provide a recommendation to the Township Board. So if we can have a roll call vote.
Chester,
I will support moving forward with a public hearing and gathering.
It's
more
yes or no?
information. Yes.
Milnick,
Yes.
Aaron's,
Yes.
Slopsma,
Yes.
Hoaxma, yes.
All right, the next item on the agenda is regarding consideration to update the current ordinance enforcement policy. And so that is in the packet with the information on that. So we need a motion to begin discussion on that.
I'll make a motion to approve the amended ordinance enforcement policy as presented.
I'll second that, Melnick.
All right, so now discussion. Tim, you're the first one on that.
No discussion from me. I think it's clear.
Okay. Who else would like to speak on this?
So just a quick question, so that we have the existing and the proposed, correct?
Yes.
In the packet, just so people
Yes.
understand that. The existing one was effective 2012.
Yes.
This one would be effective July.
Yes.
Okay.
No other comments?
No, I just want to make that clear because when I
Okay.
first looked at it, I wasn't clear myself.
Okay. Jill or Wendy, one of you want to make some comments? No comments. All right, no comments from Kester, none from Wendy. Okay, I have a couple of comments. This is different from the existing policy. The things I would say that are different is there is a very clear description of steps. This is basically a work instruction to our zoning administrator. So there's a clear description using plain English. A flow chart has been added, so there's no question regarding the sequence of steps. Clear documentation is required at the various steps as you work through the issue. So the intent is that the very first step, and this was brought up in public comment, is the zoning administrator has to go figure out by talking to the person that filed the complaint exactly what the complaint is, and is it actually in violation of any of our ordinances? Yes or no? If there's nothing there, or if it's just some personal problem, it gets closed out. So I think, I know I am aware of that, and I know our zoning administrator is. I'd last like to just emphasize that a ticket is really the last resort. And the vast majority of the time, that never needs to happen. But there are those difficult cases where people don't agree. And then at that point, you can proceed, as we've discussed, and go in front of an impartial person at the county. All right, so ready to vote? Any final comments? All right, roll call vote when ready.
Hoaxma, yes. Slopsma,
Yes.
Aaron's,
Yes.
Milnick,
Yes.
Kester.
No. All right, moving on with the agenda. The last item is consideration of general ordinance enforcement language. These are two very minor changes. We'll discuss that in a minute after we have a motion on the floor. Somebody like to make that?
I'll make a motion to approve ordinance 1 of the Whitewater Township junk ordinance, ordinance number 38 as presented.
I'll second that, Melnick.
All right, motion made by Aaron, seconded by Milnick. Discussion? Tim?
Well, just to be clear, we're just with this language as recommended by legal counsel is just incorporating it into these two general ordinances to be in compliance with some of what we've just approved. But these are general ordinances, not zoning ordinances, so it's
Correct. These are
separate.
general ordinances is separate from what the zoning ordinance is.
Right.
Okay, other comments?
I'd like to say that the definitions are actually in the ordinance and also that they have been on the website So they have been available to the public.
Okay, other comments? I have one comment, so I want to make sure everybody understands there's no change to the fine. We've added the language, including the MCL reference, which I would think that everybody would like that in there. There were also some public comments, quite a few, about junk. And I would like to clarify that this ordinance is quite simple. I encourage you to read it. It says that you may not have junk in your front yard, visible from the road right away. So let me just finish to tell you, this is what has been on the books, and it's been on the books for about 20 years, okay? So it says that you can't have it in your front yard, and that there's also some restrictions on side yards. Now, you are allowed to put up a fence. I'm just saying, or bushes. It's about visibility. So I'm just telling you what is in the ordinance and has been.
And has been for how long? 20 years?
We can't get into this back and forth.
So I just want to make sure people understand that there are other options. And like any concern, you can work with the zoning administrator on it. It's not an automatic issue. There's ways to address things. So any other comments?
I just have one comment about this. I really struggle with this one because, I mean, ultimately, the township could put a lien on somebody's home. They could lose their home for having junk in their yard. And there's just got to be a better way to deal with it. And I don't know I don't know what those answers are, but I just can't see taking somebody's home because they have junk in their yard.
Can we have the lawyer explain again what exactly he changed in these and why?
Sure.
We started with the zoning ordinance, so I wanted to make sure you had uniformity as far as the language on your enforcement mechanism for civil infractions, and it's more specific in that it refers to the Judicature Act, the statutes in there which grant the authority of the courts to handle and address municipal civil infractions. So it's just a little broader, definition. It better informs the public, better informs the zoning administrator. And then the public has the ability to look up those statutes and understand where the authority of both the township and the courts, particularly the courts in this case, comes from regarding civil infractions and what can be done. And since I'm here, I'm going to address one more comment on it. It's really up, and I think I explained this during the presentation, up to the municipality on the steps that you move forward with or where you don't move forward with. You have discretion. You have discretion to instruct your zoning administrator on how you handle these violations, each one, just like a prosecutor has discretion on charging authority or things of that nature. So it doesn't have to come to someone losing their home. It is a possibility. I don't disagree with what Treasurer Kester said, but it's a very rare occurrence.
All right, any other questions or comments from the board? All right, roll call when ready.
Milnick,
Yes.
Aaron's,
Yes.
Hoeksema, yes. Kester,
No.
Slopesma.
Yes. We have one more item and I want to, we are approaching our 3-hour limit. I've got this timer here to remind me, but I'm going to turn it off right now. Okay, so just ignore that. It came with the facility. Sorry. Okay, so we've got some time, but we will add some time to the meeting for public comment here at the end as needed.
I'll make a motion to extend the meeting beyond 3 hours.
Okay, I'll second that motion. All in favor?
Aye.
Aye. Those opposed? None opposed. Thanks. Okay. So the last item of business is regarding another existing general ordinance. So that's item 4 on the list. Somebody'd like to make that motion?
I'll make a motion to approve ordinance 2 of the Whitewater Township Parking of Vehicles Ordinance, ordinance number 63 as presented.
I'll second that motion. So discussion, Tim?
Discussion.
No discussion from you. Anybody else have any discussion on this? I would like to clarify for the public because they may not be aware. So again, what we're doing is adding the standard MCL reference. We've changed the fine to $500 for parking violations. You need to be aware that the only designated roads that this parking requirement applies to is Lakeside Trail and Baggs Road down from the boat launch. This ordinance was created about 4 years ago in response to blocking of the roadway by temporary parking, mostly associated with the boat launch on Baggs Road. Therefore, there's a resolution that was passed in November of 2022 by the prior board that restricts which side of the road you may park on and that you may not block people's driveways. So this has very limited application, and the fine was raised to standardize it and cover any towing costs or other charges that the township ends up having to pay as a result of removing of a vehicle. Any other comments?
Can I ask, I have not heard that there have been any recent problems with this. Is this
No,
has been an ongoing problem or?
I have not heard of any problems since the signs were installed and the towing threat posted.
Okay.
So to my knowledge, but I can tell you it was very severe 4 years ago. There was concern about emergency vehicles passing. So that's the only road. All right, roll call when ready.
Aaron's,
Yes.
Milnick,
Yes.
Hoaxma, yes. Slopesma,
Yes.
Kester.
Yes.
Okay, moving on with our agenda here, announcements, the next township board meeting. I wrote down here the 9th. Is that correct, or is it the 11th, Tim?
It's the
Just
9.
making sure. Okay, so that is correct. So it is July 9, 6:30 PM at the Township Hall.
No, oh, I'm sorry.
Yeah. Are there any board member announcements in addition to the next meeting?
Just one with regard to the STR survey, that there is a few more days on that to complete that survey. So if you haven't already, or if there's any questions, contact the township.
And what is the deadline? Is it Monday?
I think it's
July 3rd.
July 3rd.
July 3.
3rd.
Okay. Okay, now we're to public comment again. I'm happy to allow a little bit more time here since there's less people. So go right ahead, Connie.
Connie Highmore, Baggs Road. First, I want to say I support the zoning administrator. She doesn't make the laws. She's been hired to do a job, enforce ordinances. This isn't her fault. She's professional, answers calls and emails, and does her work in a timely manner. Thank you, Deb Graber, for working hard in this township. You're a valuable employee. I've awaited the supervisor's public apology to the zoning administrator for disrespecting her several months ago during a board meeting. Tonight at time marker 8:43, the supervisor was disrespectful once again. It's your tone. It's the way you talk to her. It's just not fair. She works so hard. You'll be lucky she doesn't walk away from this circus. She's taken a beating tonight, and I want to say, I'm sorry that's happened to you, Deb. You're doing your job. I'll finish my public comment from earlier. I repeat, all the charges are declined against Clerk Hoaxma. The board has known about this for 12 days. Since then, there has been a board meeting. No transparency concerning this case was shared by this board. The clerk was not given an apology, quite the opposite. It seems my FOIA request has pulled a
text message that was sent from Jill, the treasurer, to Linda, but inadvertently was sent to the entire board, creating an open meeting act violation. And it seems as if they're going to continue to go after the clerk, or she'd like to. This text came after the clerk was exonerated, but it appears that her trial by peers is not over. The clerk was guilty until proven innocent, and even now, after all the charges are declined, people on this board want to continue wasting time and money on this ridiculous slander case. In April, the cost of this case exceeded $10,000. $10,000 to recoup $3,000. It failed. And since April, an additional employment attorney was hired. You can't imagine the cost, but my FOIA will give me that answer. The clerk did the work. The clerk earned the money. Stop wasting taxpayer dollars and put this failed slanderous case behind you. I await your public apology to the clerk at the next board meeting. Do the right thing. All right, who else would like to make a public comment?
I would like it on the record what you're gonna do about houses that were built before this township had zoning rules, like my place, where it only has a 30-foot backyard. When it comes to putting up fences that I should not financially have to put up for things in my yard that are legally there. Like, what's your answer to that?
I think it's something that we would need to review, quite frankly.
Well,
And I think
should
you
have
have,
reviewed that first.
I think you have a concern, and it's an individual property
It's not
concern.
an individual property concern. It's every house on my freaking road. My family used to own half the property on the road, and it was split up before this was a township. Houses were put wherever they wanted to. Like, you need to look at your maps. You don't understand where stuff's at. Okay? The other thing is these new cameras that we're supposed to be getting. I don't know a whole lot about them, but I do know that the Supreme Court ruled that cameras that were not supervised by a police officer at time are not admissible as evidence in court, as standing on their own merit. There has to be a physical person present seeing the crime committed or the violation. So you've wasted our tax dollars on those.
Okay, could I request to talk to you after the meeting, please?
You can talk to me all you want, but you're not gonna like the answers.
Sir,
Thank
could
you.
you please repeat your name for the record?
Randy Davy,
Thank you. How do you spell Davy, please?
D-A-V-E-Y.
Thank you.
All right, who else would like to make a public comment?
Okay, I have just 4 topics to cover. First of all, I want to thank Deb too. And I'm Barb Dean. Got my addresses. We're good. Okay. All right. So I want to thank Deb because she doesn't follow the process that I'm aware of that's described in the current ordinance that I looked at. It says go out and find information and then contact the resident. And what I find with her is she tries to resolve the issue to begin with. So thank you for that, because I think that's the way it should happen, as I mentioned, and I didn't want to imply she was doing it differently. Okay, so that covers that. Junk. My farm has junk in the back, junk. We've rebuilt shakers in the middle of the season when we needed slats off the old shaker conveyor belt. My son has made 2 inventions, one recognized by the state and the Hemp Association, from the junk he's taken, cut apart things in the back and saved paying wages for 3 people so he could harvest by himself. My son is in the process of creating another. I sewed the netting for it yesterday. Another thing to help him process in the barn because he has orders for 50 pounds. Do you know how long it takes to trim 50 pounds, hand touched, not trim it, of hemp buds? It's not possible for him to do that and also plant and also clone and also run the cherry farm. He's used that stuff and reuses it all the time. Can we build a fence along Elk Lake Road to block that out? Oh my God, seriously, you know where I'm at? I'm from Hubbles to Hubbles. Okay, build a fence? No, it's not gonna happen. We've built 2 extra barns. It doesn't all fit in there. We've lined them up. When the insurance lady comes out and says this, and this, we do it. They come back and do it because we have umbrella insurances. But put up a fence along Elk Lake Road to hire this stuff that's being used or utilized when we need it. Okay. Sure. It's not junk. It's okay. So then the STR survey, just today in the mail, I got my number today. I went to the township yesterday and said, please, can you tell me how I did that? Do that. I called them yesterday, was able to get that my number and to fill it out. But today was the first day that that card got in my mailbox. I check 3 mailboxes every day for 2 weeks. Okay. So for people that would like the number, I provided to somebody else here. Here's the letter I got from our township office highlighted. You can call and ask him. But the deadline is the 3rd, and we just got it today. I waited patiently because I understood the process, phone interview. Okay, and that they're not going to put out the stuff. And then I thought, well, okay, it's going to come in the mail. My sister-in-law said, I got mine and I got a phone call. I said, great. Then I began checking my mailboxes, 3 of them every single day. And I still only received today the numbers. I think that's a problem with the survey process. And I know somebody else in this room hasn't received it yet. So we're talking pretty late for responding to survey. Yes, you sent it out. My sister-in-law doesn't use. Oh, I went and got it's back up. Okay, there you are. I went and got a paper one for her to fill out. I found out that I asked the guy, can I just put multiple paper ones in one envelope? You know what? They all have the right code. And he said, yes, just send it that way and save the postage. Cause I said, I can use our business postage. We'll stuff them in an envelope. I'll get them because I have family members that do not use the internet, aren't going to. So I went and got their codes and we did that and delivered their surveys today and said, I'll pick them up tomorrow. So, but I think that's a little short on the timeline with the code. I don't know where the problem came from, but I'm telling you, for me, that was the case.
Mike Jacobson, Skigmog Point Road. I'd like to apologize to you, Wendy. In the spirit of transparency, the community wanted to know what was going on. And there were people sitting in that room at the tables of the board who were accusing you of stuff. Shame on them for acting that way and doing that. So sincere personal apology. What the lawyer told us today about the fines, $500 is not what was in your old verbiage. Daily fines there's a big difference. That creates a big stir in the community. You got to understand that. Come on, you got that much common sense, right? Safety of an individual at a meeting. I don't know a man in this crowd that would let harm come to anyone voicing their opinion. However, we all have the right to speak our minds and should in America. I personally know that I have a kind of a booming voice and I'm animated. It does not mean I mean harm to anybody. It's just my personality. I never meant to scare anybody. I don't walk around trying to use that to scare people. So this is a rural community and people will have your back if somebody tries to cause you harm. I guarantee that. I've seen it plenty of times. The marijuana issue was put down and stomped out by a much smaller crowd than comes here and voices their opinion about not wanting the civil infractions ordinance. So how the body of government cannot listen to the people when they have such a majority boggles my mind. When it's an issue that they are behind, they're more than willing to listen to a few people. But when it's an issue they're not behind, they don't care how many people come here. That's not how the American system works. I can't speak for everybody, but most people don't mean the zoning administrator is going to be targeting them. It's the neighbor who thinks they are better than you or me or whoever they're targeting, and they sick the zoning administrator on her. And basic rules, I kind of want to speak to that. When the zoning administrator suggests a licensed camper in my driveway be moved, that isn't basic to me. We use it, it's licensed, it's my property, and it's legal for me to own it. That is letting a neighbor who doesn't like that it's an old camper harass me. I'd like to know why you won't let the lawyer explain to us how the planning commission can make laws, ordinances, when the Constitution says only the Senate and the House of Representatives have that power. As far as the junk thing, you all want to call it junk. The stuff in my yard is not junk. It is projects. It is things I'm trying to accomplish, things I'm trying to fix, things I'm trying to remedy and or build. My house was built before zoning existed. My house is so close to the road that it's in the setback. When my truck is parked in my driveway, the front bumper is basically at the road right away. That's not my fault. The house was built before there was zoning. So the stuff in and I don't have a shop. I don't have a pole barn. I don't have a garage. I don't have a shop. My table saw sits out there. My grinder sits out there. Rakes and shovels sit out there. The project I'm working on at the moment, or the half a dozen projects I'm trying to fix, because you know how stuff happens. Those are my things. Those are my projects. That's my driveway. That's my work area. That's not junk. Also, with that being said, out my back door, about 7 feet from my back door, the hill goes straight up. Okay, so put the stuff in my backyard. There is no backyard. Oh, wait, there is a backyard. But the board has invited the whole world to parade through my backyard via the Losi Road Trail. Okay, there's a pretty good pile of very expensive raw material in my yard where I can keep an eye on it because vandals and thieves are rampant. I will be damned if I will put it in the backyard so somebody can steal it. This raw material is used. I don't buy very many gifts. I make them. So for the very biggest share of it, all these art project things that I make are gifts. I am not going to put the raw material where it can be stolen. Putting a fence up so you can't see it makes it so I can't even get in my driveway. We all have individual situations. To lump this all together and penalize everybody on, the same, you're not taking into consideration that we all have individual situations. You all have your own individual situations.
So Mike, I'm not sure how much more material you have, but could you please hit your key points?
This civil infractions ordinance makes people feel like uh, guilty until proven innocent is the situation, and that's not the situation in America. In America, innocent until proven guilty. And basically, that's it. I want to thank you for your time and your energy, and please let the public speak. That's your job.
Dave Williams, Watson Road. I spoke earlier and I got a little bit sidetracked. And I wanted to speak more on the definitions issue. Definitions is, if you're gonna have a penalty for something, there has to be a definition of the crime. Now, as Wendy pointed out earlier, there are definitions. They're entirely vague or they're inaccurate. By the junk ordinance, every single one of your vehicles is junk. It says so right there in the ordinance. If it's reduced from its brand new initial capacity, if it's weathered, if it's worn, it's junk. So you guys can't have cars anymore. Is your house as good as it was the day it was new? No. Are your shoes as good as they were the day they were new? No, they're weathered, they're worn. That makes them junk by the definition. As we have vague definitions like blight or eyesore, as I mentioned earlier, or many other words that have legal definitions that are different and they're depending on where you're from, if what circuit you're in. That stuff needs to be defined more accurately if we're going to have a penalty for a specific thing. It has to be a specific crime. Using vague words that give you the ability to maneuver around and place everything on a case by case basis just means it's not fair for everyone. If the purpose is to have fairness, as has been mentioned earlier, I don't know that I agree with that, but if that's the purpose, we missed it. What is the goal of the civil ordinance? It's to enforce the civil laws that we already have on the books. But if the laws are bad, if they're poor, you're putting the cart before the horse. It's like Obamacare. You got to read it. You got to pass it to see what's in it. Well, that doesn't make any sense. Let's fix the problems before we pass some sort of ordinance that is going to allow the enforcement to be on a case by case basis based upon whose judgment. Is there some lawn boundary picker outer guy? Is that an elected position? Is that an appointed position? If the lawn, if your lawn is defined in the zoning ordinance, which it's not, as we've talked before, the lawn could be where you mowed it last year. Well, what if you don't want to mow it where you mowed it last year? Maybe last year your kids played soccer and they wanted room to run free. This year they don't play soccer. You don't need to mow the whole county. Well, that could be up to interpretation, and now you can be placed on a fine. The lawyer has stated that the $500 per day civil infraction is unusual and that it's not commonplace to charge that, but it is legally able to. Now, we're going to look at changing from a criminal charge to a civil charge because, as you guys have stated, it's too expensive to go to court for all these. I agree, but now you just put the burden on the person, on the innocent individual until they're proven guilty. They have to stomach the charge, $500 per day, potentially. Are you guys prepared to go to court over an individual charge every single day? If I go to work for 2 weeks out of town and I come back and I've had 14 individual lawn citations, that's $7,000. I'm gonna take those to court. It's gonna take us a month. That's how many more charges? Are you guys prepared to go to court and fight 14 individual charges for a $500 fee? I'm not. You aren't. It's our money. Why even bother with the enforcement until the rules are sorted out? They have to have definitions. What is a lawn? Where are the boundaries? If you can't define what are the boundaries, get rid of the rule. There's plenty of problems in the world to work on. Why work on fixing a problem that hasn't had a basis that's solved yet? We have to fix the problems before we bicker about enforcement. Is a civil infraction, misdemeanor, Which way is it? Who cares? The problem is not in the enforcement. The problem is in the in the ordinance itself. We don't have accurate definitions on anything. It's all personal decision. That's not a way to have a law. That's not a way to enforce anything. What you might like, maybe I don't like. I think she's nice. I might think she's mean, but you might think the other way around. We can't pass a law based upon who somebody thinks is what. There has to be a definition and a legal definition. Just, we got to table the entire enforcement issue and work on the actual issues, which is that we have 53-year-old laws that are irrelevant to our world. Scrap the whole thing. It obviously doesn't work. If it doesn't work, why work with all the enforcement? Just throw it away. Let's start a new operation. We got to define what the problems that we're trying to solve are. Do we want to have a community where we all get along and we all work together? I do. That's the community I've lived in for my entire life. Let's embrace that. We're pitting against everybody against each other, and it's nonsense. Let's do the work, just figure out the problem and solve the problem before we worry about enforcement. And that goes for short-term rentals, that goes for lawns, that goes for zoning issues, it goes for the definition of junk, which includes a one-day-old car. Let's sort that stuff out.
Okay, thank you.
Thank you for your time.
All right, thank you very much. Anybody else like to step forward and make a public comment?
Hi, Michelle, and I will make this short. I had 2 points. You know, my job, I have the skill set of active listening to everyone involved. And what I've concluded is that our ordinances and the answers that we've received regarding the ordinances are, as stated, the gentleman spoke, vague and left up to interpretation by all parties involved. This clear as mud situation, that is our concern. Maybe start with this issue, and then we can move on to civil infractions. Also, too, fear. I feared being here. I would rather keep to myself. There was a woman here. Her and I may not see eye to eye, but I will protect you just as I know you'll protect me. And that's the type of township I would like to live in. So I appreciate everyone's time tonight. Thank you.
Would anybody else like to make a comment?
I just, Randy Steelman, Chris Road. I just wanted to bring up, we've been talking about our zoning ordinances not being up to snuff, and I know you guys are working on them, and I appreciate everything that you've done for the most part. But one of the things that really irks me is there was a lady here that's, gone to jail and everything else over a extremely unclear zoning violation. There's not one word in our zoning about short-term rentals specifically. And yet she's been, put through the ringer. I don't know the details. I'm sure she must be doing, whatever's going on there is really bad, or you guys wouldn't be going after her. And I appreciate, that's what I want. If something's really bad, go after it. That's fine. But I don't want it to be easy for people to just come at people because they have a STR versus they have a bad STR. It's a big difference. And we don't even have a rule against it. If you guys want to, make STRs illegal, which you've said they are, but you could certainly take a vote and make STRs legal or illegal and put it in there. Make it clear so people know, rather than just a newsletter from years ago and, all this weird lawyer, deep stuff. Just make it clear. If that's what we want, is rules that are clear. So please think of that when you're making the civil infraction ordinance. You're allowing, any zoning person, not Deb, I don't want to yell at her, but any zoning person, you tell them, hey, this is illegal here, even though it's not written there, and they're going to go follow it that's their job. So please, get that sorted out, even if, I think that that'd be wrong to do that, but that's just a really super great example of what could happen with this civil infraction thing, for anything that is not written in the zoning thing. We just make this stuff up. Back to, we're just putting the cart in front of the horse. And you know, things in this township were way, way better as far as government and people being upset with each other and their neighbors and stuff like that. They were way better here. Just a couple of years ago, they only had a few complaints a year about this and about that. And now you guys are overwhelmed, getting ran out by complaints and problems and things like that. So obviously the bringing this stuff up and whatever has gotten everybody riled up. And I just feel bad for our whole township for having to deal with it all. And you guys too. And I'm sorry that you guys have to sit here and get yelled at and take blame and everything from every administration before you and everything else. I just hope that you guys make good decisions and right decisions and, you know, try to think about the people that are, you know, obviously care enough to come in here and post our opinions with you. Thank you all. Good night.
Thank you, Randy. Jim.
James Snyder, 8316 Oldham 72, Williamsburg, Michigan. Yeah, I'll tell you what, I learned long ago. I've lived here for almost 40 years, since 1988. And CYA, we all know what that means. I learned soon on, you need to do that, protect yourself, get documents, get receipts, have the receipts and stuff. When I actually went against, the township didn't take me, they pawned me off to the county. So I was up against Al Schneider in Grand Traverse County by myself with an attorney's help, and I actually won. And what happened was everything that I have, just like I have now, my boats, my cars and things like that, my convertible, there's a convertible out there right now. That's not junk. I drive it. It was at the St. Angus Car Show. You can look online. And I had an Oldsmobile convertible that was on the judge's order that I had to get rid of. And it's like, this is crazy what they did. And people don't understand. I was pretty much on my own. I didn't throw any of my neighbors under the bus. I didn't send any of the 2,000 photos of everybody else doing it. The way you guys are going about this, you are selective enforcing the zoning by only going by anonymous complaints, only doing this. If everybody's breaking the law, everybody's got to go hire somebody 40 hours a week to go and take care of it. You know, I don't think the people want that. In one of the junk ordinance thing, I had a clown car because you guys have, it's got to be registered cars, whatever. I had a clown car that has a wheel and mills, a 1928 Model A Ford in my backyard that I use for different things. I don't drive it down the road legally. I just take it places and have fun with it. And it came from Gaylord at Gale Rancho. It was a dude ranch over there. And the judge asked me about it. I told him, I said, yeah, it doesn't have a title because I don't drive it down the road. It's not junk. It operates, it does what it does. People have stuff like that. If they have 2 or 3 lawnmowers, they're not necessarily junk. But so that's just kind of some of the stuff. When I was going against the township before, it cost the township $40,000 to get me to get rid of my boats and put them in another building for a while. But then I kind of gave up because everybody else was doing, I was the only guy in northern Michigan that could not have anything in his yard unless I was using it. They got lawn furniture, barbecue grill, my wife's windmill ornament, all on the judge's order. You can look it up. I got copies. I'd be glad to give it to you. I got the transcripts. It's total harassment, and they trespass on my property, get photos over my fence. That's a big thing. You guys keep bringing up the fence deal. Like, well, in the junk ordinance, as long as you have a fence and nobody can see it from the road, it's okay by us. Well, holy crap, if they got like barrels with skull and crossbones on it, you can't see it, that's a problem. You know, that's junk. That's something that's the health, safety, and welfare of the community, that if I saw my neighbor, I would turn my neighbor in if I saw these barrels there for 10 years with skull and crossbones. There could be an issue. But a fiberglass boat sitting there on a trailer, it's going to sit there for 50, 100 years. It's not going to decompose into the ground. It hurts your eyes. I'm real sorry that that's what it is. You know, people need to understand that junk ordinance is totally different than the outside storage. Outside storage, nobody can have anything. Like was mentioned before, you can't have stuff outside. It has to be in an approved building. That's what the zoning says. And let's see. Oh, on the survey thing, my neighbor, we talked to my neighbor. She didn't get a survey. Only 2 of our properties got the survey. our main residents didn't get the survey and somebody else has told us they didn't get the survey. So it's not getting to the people, you know, and a survey should be everybody. So something's going on with that. And blight, that's been brought up, you know, and stuff. Blight is related to things that are hazardous, safety issue, like a building falling down, a car flipped on its side and oil, gas draining out of it. That's what blight is, or garbage that like varmints and all these stuff come in. And that brings up the subject. 3 years ago or so, somebody from Truax Lake put on Nextdoor app, whatever it is, my building, the old fire station, that, hey, people, we've got a junkyard in downtown Williamsburg. Did you know that? It's got toxic chemicals, varmints, rodents, the whole thing. Well, people shut the guy down. And anyways, right after he did that, within a couple days, because I found out the day it happened and I looked at it, somebody threw raw meat in the front of my building, and I found it right away because I'm there all the time. So they were trying to draw something in. And then recently I talked to Josh, the fire chief. I said, hey, I'd like to see the film on your thing, because can I have a couple seconds about this? You have a camera that's focused on my property. And he said he would look, and I know it happened within the 7-day time frame that you have the security camera going for, of who threw a bag of filleted fish with maggots in the front of my property. And I know when it got there, because I was there before it wasn't there, and then it was there. So I know it's on the videotape. And this is the people you got in our community that are like shoving down things on me, you know, because I have stuff. I'm trying to clean it up for my benefit, not for my other people. I'm trying to make my life a little bit nicer, and I'm trying to work with the township as I'm trying to show. I'm just saying, I don't need neighbors or people on Truax Lake throwing garbage in my yard. It's happened on 3 occasions. I don't live there. I don't eat there. I don't have garbage over there. I have steel things, you know, that's it. I'm just telling you, you need to watch where you're getting your anonymous complaints from and what it states. I don't have a problem with my neighbor having $1 million RV behind his garage. I don't care. But if he's complaining about it, Jesus Christ, what are we going to do? Thank you.
Thanks, Jim. Kim?
Kim Mangus, 5101 Brown Bear. And I apologize to anybody. I don't need the mic and I can't help that it's here. I have a naturally voice that does not need a microphone. And I understand that. Jill, you asked a question about what other type of zoning could we use? And I think there's something, and we don't talk about it because it's definitely in the weeds for zoning. Something you should be aware of. Our ordinance was not written as a permissive ordinance. Our ordinance was written as a prescriptive ordinance. Originally, our ordinance just said what wasn't allowed and what was allowed, and that was it. There was none of this, if it's not in there, it's illegal. It was very, very defined. It didn't cover very many topics, but that's the way it was written. Progressively over the last about 20 years, it has been slowly, article by article, rewritten to be permissive. It has been restructured. And now that it's been recodified, it is completely shifted over. But it was never written to include every possible use, every possible issue. That is my understanding. Mr. Milnick, we don't agree on things, and that's fine. But you seem to think that you are the first person that showed up and tried to fix the ordinance. You're not. Yeah, I spent 15 years on the Planning Commission. And no, we didn't get the whole zoning ordinance fixed. We didn't even get half of the zoning ordinance fixed. Is that my fault? You know what? I was one vote. Yeah, if it had just been me, I could have rewritten the whole thing and just put it on the books. But that's not the way our system works. Our system is checks and balances, multiple people, and you have to work together with the community, with your board, with your fellow planning commissioners to try to get things to work. Now, when you guys took office, you're currently prosecuting people for short-term rental that is never mentioned in any manner, shape, or form in our ordinance. And we're currently prosecuting someone for that. When you took office, the majority of our zoning ordinance was stamped draft. Did the attorney know that? What reasonable person is going to think that that's an ordinance that's in effect? I don't agree with that decision. I had nothing to do with that decision. I strongly argued against that decision because you should not be enforcing an ordinance that is labeled draft. It was ridiculous. But the only way that we could fix it was one by one, myself and other planning commissioners that have spoken up here and others that were in office. We corrected as many articles as we could, as fast as we could. It wasn't a good situation. It's not a good history, but it is the history. Right now, you're enforcing short-term rentals. You should not be enforcing an ordinance that is not on the books. There is no mention of short-term rentals anywhere in our ordinance. Now, I understand this is about civil infractions, but it's not just about civil infractions, because we have people in our community who are doing things that they had every reason to believe were completely and totally lawful use. They were told it was a lawful use. And now we've just set up an organization, or we have set the groundwork to pass to the Planning Commission to make a change in our ordinance to create a $500 a day fine. Where is a $5 a day fine going to be implemented? The same place that a one-day jail sentence that this attorney has never seen before happened, short-term rentals. There's been discussion about the gentleman here, about his property and putting up a fence, and you can discuss it. You can discuss it with Mike. I happen to know neither one of them have any physical way to ever fence their property and keep it concealed. The gentleman over there, he could put up a 30-foot fence and he would still be visible from off of the property. Yes. There it is. This is not a cornfield. We are a moraine. We are at the tip of the Great Lakes. We have hills and valleys and ravines, and that's what makes our township absolutely beautiful. And that's why a lot of us chose this area. It also makes it impossible to fence. There needs to be some consideration for the fact that not all of our ordinances are up to snuff to be reasonably interpreted, to be reasonably fair, and to take into account the conditions that are already established and many times were established before zoning even existed. Thank you.
Would anybody else like to make a public comment tonight? All right, with that, we're going to move on to board comments. One more. I'm sorry, did somebody stand up? Hi, Jessica, come on forward. Sorry, I was looking at my paper, didn't see you stand.
At the crowd to make sure I wasn't taking anybody's turn.
Okay.
Jessica Mangus, 5101 Brown Bear Lane. I just had something or a few quick things to add. I know you guys have a very professional individual currently who is doing an excellent job, it looks like, on all the tech right now. And I was wondering, since the timer is a pretty reoccurring character at this point, and apparently it can change, depending on the meeting, would it be possible to display it in some way so that the person giving the comment could see it visually, just so they can time it out a little better?
Yeah, thank you for the suggestion, Jessica.
All right, certainly. And then I swear there was something else I wanted to say. And in the meantime, I'm just going to fill it with a brief moment of not dead air, but I think for the second half, everyone's very tired. And I just wanted to acknowledge everybody here and say thank you, everyone, for coming. It's a long drive out. You guys have all still been giving your full attention. Everybody here's been doing what I always do when I come to one of these things and gone, okay, I'm going to go home at some point here, but I want to see the very end. And I might be the end of that, so we can all go home. But it's always nice to see what our community is actually capable of when it comes to sharing some of their stories. There's some very valuable personal stories that I got the pleasure of seeing today, and it was very informative, the presentation earlier that you gave, sir. I didn't get a chance to quite mention it earlier, but you did a very nice job. That's all I wanted to give. And thank you very much for your time.
Thanks, Jessica. All right. Anybody else? Last chance. All right, now we've got board comments. Any additional board comments anybody has?
I do.
Go ahead, Randy.
Yeah, I just want to follow up on Randy Steelman's comment about the good old days here and how things were great. And also want to address the Elk Rapids News advertisement. I was disappointed that it talked about Whitewater Township as being a living soap opera. I don't think it's helpful to cast our community in a light like that. I think it's equally disturbing that if you want to continue with the soap opera analogy, you'll find some of the worst episodes happened when different people were in charge. The very first meeting I went to in 2022, I saw the Planning Commission tried to update our master plan. Some of you may recall the process imploded. Both a consultant and a PC member walked off, left the meeting. We made state and local news about that. And the conflicting issue had to do with demographics. How many people are here? What are their characteristics? And if you want to read that, go back to the ticker article, March 16th, 2022. It's all there. It was more than a soap opera. It was terribly embarrassing. The ad in the Elk Rapids News also mentions the lawsuit, and the lawsuit actually has roots in actions taken several years ago. We can't go into them because of pending litigation, but suffice it to say, no board member or planning commission member in place now was involved. So Whitewater Township has been a soap opera, but not because of the current board members or the current PC members. I look at us as having to do some cleanup after some ugly food fights, and we have good people here trying to move us past the soap opera days and get to more professional local government that reflects what people want in their ordinances. And again, you know, we got to separate the enforcement mechanism from what the ordinances require. There is work to do on those. I'd urge people who want to get involved to do so. We need good people. We need good insights. I welcome it. I know other members of the board and planning commission do as well. So that's my comment.
Any other comments? It's late.
You concerned more with what it looks like or what? Right. It seems like you're more concerned with what it looks like public, doesn't live in this.
Okay, I think we're ready for a motion to adjourn. I'll make that motion.
Second it.
Seconded by Milnick. All in favor?
Aye.
Okay.